Live streaming.
Yes, wait, look, in this matter, we are supposed to file an affidavit explaining the delay in filing the review petition. So we are working on it, madam. So I need some time to file it, madam.
You have filed a review petition.
Yes, madam.
And you do not do your homework.
Yes, madam.
You want to do your homework after filing the review petition to explain the delay.
On last occasion, madam, my senior they have raised the issue, madam, regarding
How long? What is the delay?
delay, madam? We are not.
How long is the delay? How long is the delay?
Delay, madam. Order was passed on 26/10/2017, madam.
Yes.
Almost like 2 years.
2 years. And how long you will take to explain the delay?
Immediately after vacation, madam.
Immediately after vacation. So you have already taken about a month. Huh?
Yes,
You will take
madam.
another month. Okay, very well. If you continue taking your time to explain the delay, that will also be added
Yes, yes, madam.
to the already delay. Okay, don't think that it will be subtracted. It will be added. Huh?
Yes, madam.
You have to explain why you have taken 2 more months to explain also.
Yes, madam. That I explained, madam.
Yes, you have to explain everything because every day has to be explained. That's what the law says. Okay. Mr.
NJ Khatuniya, madam.
L.J. Khatuniar, learned standing counsel or
Yes, yes.
standing counsel for
Education Elementary Department.
Education Elementary Department seeks further time to file the affidavit to explain the delay in filing the review petition. Are also Mr.
PJ Das, your lordship.
P.J. Das, PJ learned counsel for the respondents. List accordingly after vacation. When do you want?
Madam, on 15th of November, madam. It's a Tuesday.
15th of November. More than 2, almost about
Then,
2
madam,
months. Huh?
madam, on
Almost 2 months. Huh? You
second
will
week also,
take 2 months to explain.
on second week also, madam.
Huh?
Second week also, madam. 7, 8 is holiday, madam. On 7.
Huh?
After Children's Day celebrations.
After Children's Day celebration, my lord is saying. Huh?
Yes,
He'll
madam.
be busy with the children's affair.
Yes, madam.
But then these are Siksha Sarathi who are supposed to teach the children. We are not perhaps giving too much attention to the teachers. Okay. Well, let's again on Tariq.
7-11.
7/11 you
Yes,
said?
yes, yes.
7th of November is prayed by Mr. Khatuniar.
List of.
Hablar.
Leave meeting. No.
Item number 7, my lord, this matter may be adjourned for 30. After vacation.
Item number 7,
Yes.
Fulchan Ali,
Yes, ma'am.
on the prayer of Mr.
SR Gurbuya.
S.R. Gogoi.
Gurbuya.
Huh?
SR
Guru Bhaiya,
Yes.
okay. Let the matter be listed in, when?
After vacation.
After vacation.
Okay.
May I please, Your Lordship?
Yes,
My Lord, I beg to mention for listing, my Lord, in motion, my FT matter. Petitioners are in jail, my Lord.
so what to do? If
My
you are
lord.
in jail, then you are in jail.
My Lord,
If you are in jail, you are in jail. What to do? Tell us.
my Lord, taken up it on, my Lord, 29th of
What?
this month, my Lord,
29th of what?
day after tomorrow.
Why? It is,
For list, I have
when
paid
did you
for-
file this application?
My Lord, already numbered, my Lord. I have filed it on, my Lord, 16/9. The bench is not available. my
Today is what day? September 20.
7. Today is
7.
27.
1, 2, 3. 3 days left.
Yes, on
Okay.
oblige me.
May I please, Your Honor, for listing the
What?
foreigners tribunal matters, Lordship, I have no
We
received
are
any
criminal-
notice
we are
expertise,
criminal judge here. We'll send everybody to jail.
Lordship,
Hmm?
expertise order, Lordship.
What expertise?
The notice was hanged in tree, Lordship.
Huh?
Tree, Lordship. Notice was hanged in tree, Lordship.
In your house, mango tree in your house.
No, Lordship.
Huh?
Lordship, the petition was arrested, Lordship.
So good. He will get.
29,
He's safe there. You are safe. Okay. 29.
May I please, Your Lordship? Lordship, I beg to mention a motion matter for listing.
What? Which matter?
This is also FT matter. Okay.
That please, Your Lordship. I beg
Yes.
to mention item number 6, Your Lordship.
Item number 6.
My
What-
prayer for listing after vacation, Your Lordship.
On the prayer of Mr.
AAR Kari.
A.R. Kori. Let the matter be listed. Yes.
May I pray for a date, Your Lordship.
Hmm?
May I pray for a date, mechanically.
What date is dated? Today's date. Why you are not prepared?
Oblige.
Huh?
Oblige.
Which date you want? Of the 6? Which one? You are mentioning which item?
Item number 6.
6.
Item number 6. Today is the date.
Password for the day, Your Lordship. I'm after vacation. Your
Why?
Lordship.
Why?
It's due to shifting of chamber, Your
Huh?
Lordship. File was misplaced, Your Lordship.
Shifting of chamber file displays.
After vacation.
Are you
Any
sure you'll get the file after vacation?
Lordship.
Huh?
Lordship.
You first get the file and make a mention. Otherwise, what will happen that we'll fix a date. On that day, we'll say, no, file is still missing. And our registry will be running around to put your case. So you first get your file, make a mention, show the file in the court. Yes, this is the file we have recovered. Kindly list it. Then we'll allow.
Oblige.
Okay. No, we don't do on contingency. Huh?
Oblige.
Yes. After vacation.
Supplementary list for motion item 14.
Madam Ghosh is missing lot.
Where is Ghosh? Huh? Busy in another court.
I haven't seen her lot.
You didn't see her in the court today.
No, Lord.
What about Deka? What about Sauradip De? I Chakma, P Nag, SK Chakma, a battery of lawyers, all deserted. What to do, Verma?
Lord may examine the matter. Each
Examine
notice
matter.
lordship.
Very well. Lucky. The other side is lucky. Yes.
Puja bonus lord.
Issue notice. But then what else is to be done?
Interim lordship is in detention.
Huh? They're in detention.
Yeah, proceedings in detention.
Their proceedings in detention. But then they may seek for a bail or something like that. Proceedings in detention.
Where's
Hmm?
lordship? Page 11.
Page 11.
Page 11, schedule 2 lordship.
Oh. Then let us tomorrow then, if she is not here. Because then tomorrow then she will come for bail again. Hmm?
After some time lordship, time being.
Okay, then you wait. Let us see what Ghosh will say. After some time, for a time being.
Okay.
Daily list for admission, item number 1.
Ghosh.
I apologize, Lordship.
You take a breath.
Sorry, Lordship.
Traffic jam.
Supplementary, item number 14.
Yes, Lordship.
Item number 14, no?
My lord,
Yes.
petitioner is declared as a foreigner as per order dated 36/22, Lordship. And since then, he is in detention camp, in Jorhat detention camp. And from the foreigners tribunal itself, he was taken to the camp. And the order was not passed. When he was not there, then the order was not passed. The day he appeared, and thereafter, order was passed and he was declared as.
If you are declared a foreigner, then you have to be detained. That's the law.
Yes, Lordship, but
Yeah.
usually can be represented by the council. All along, he was represented by the council. That day, order was not passed unless and until his presence was there.
Obviously, the tribunal is not interested in the council. He is
Yes,
interested, tribunal interested in the person
Yes,
who is
Lordship.
found to be a foreigner.
On merits, let me submit, Lordship.
Yes.
On merits, he has exhibited voters list of 1966 of his father and stepmother. Then 1970 voters list of his father and stepmother. Subsequent, he also casted his vote along with his parents. 2011 voters list, where Hussain Ali, his father, then Quran Ali. Lordship, page number 50.
Yes. Who else has been examined as witnesses? in this case?
His stepbrother has been elder brother, step-elder brother has been.
Can we call for the records and we'll examine your
Yes,
case?
Lordship.
Huh?
Meanwhile, my humble prayer will be to release me from the detention.
But then you have to make out some
Yes, I have submitted.
substantial point to
The
see
substantial
for
points I have, Lordship.
what
Yes,
is it?
there
Tell
are
us.
66 voters list, and I have casted vote along with my father. Linkage with my father is very clear. And all
Shows that,
along,
shows that.
yes, Lordship. And all along, I am in the same village.
Shows that, shows that.
Yes, Lordship. Page 38, Lordship.
Page 38.
Yes, Lordship. '66 voters list.
Hussain Ali.
Yes,
Who is
Lordship.
Hussain Ali?
My father.
Gwalpara,
Yes, Lordship.
Kathuri village. Then
70 voters list.
page
Page 39, Lordship.
Kathuri village, Gwalpara.
Yes, Lordship.
Hussain
Then-
Ali, son of Sohan.
Yes, Lordship.
Then
2011 Lordship voters list. Page 49,
yes,
Lordship. Hussain Ali.
just a minute, page 49.
Yes, Lordship.
Same village, same village,
Yes, Lordship.
not shifted to another village.
Pashtim, because subsequently name was in, but the same main village
Kathuri,
is same.
Lokhipur, Gwalpara.
Yes, Lordship.
What is your name?
My name is at page number one, serial number 125, page 50, Lordship.
Puronali, you are Puronali.
Quran Ali.
Puranali. Puranali
Yes,
is a
Lordship.
very is out of Pranali.
Yes,
Quran.
Quran. Quran means life.
And Hussain Ali,
Hassan Ali is my father, Lordship.
Okay. Yes, the same village, same.
And Lordship
There is
page,
a- there is- huh?
Examine the
Yes.
matter at this stage, notice, record
But
and
then let her go out. Let him
Yes,
go out
Lord.
because he appears to be in the same village. Father also the same village since 1966. Name and the father. Okay, and Ms. goes Lana Council for the. Okay. Last Ms. goes Lana Council for the petitioner. Issue notice renewable 4 weeks. Ms. A. Verma accepts notice on behalf of
2 and 3, Lordship,
respondent number
2 and 3.
2 and 3. Devi, 1 and Miss A. Yes, Devi. Exception on 1 and 4. And 5 and 5. What about 6, 5 and 6? 6. Okay, Miss A. Fuka. Accept notice of respondent number 6. What about election commission?
He's around somewhere, I thought.
Call him just. What is his name?
Hey, Ali.
Ali. Ali accept notice on board, respondent number 5. Call for the records. It has been submitted by Ms. D. Ghosh that pursuant to the impugned opinion of the tribunal passed on 36/2022 in FT case number JFT.01/2020 passed by the Foreigners Tribunal Jorhat. The petitioner, having been declared a foreigner, has been kept in detention in where?
Jorhat,
In Jorhat?
here.
Jorhat what?
Jorhat Central Jail, Jorhat Detention Center.
Jorhat Detention Center located in Jorhat Central Jail.
Yes, Lord.
It has been submitted that the petitioner otherwise has been all along under bail during the proceeding. That apart, the petitioner has a very strong case in his favor to show that he is an Indian, not a foreigner. In this regard, Ms. D. Ghosh has drawn attention of this court to the voters list of 1966, in which the name of the petitioner, name of the petitioner, name of the projected father of the petitioner, it is Hassan Ali, son of late Sobhan, is shown to be included in a voter list of 1966 in respect of 44 Gwalpara West Legislative Assembly constituency as a resident of Kathuri village under subdivision Gwalpara Sadar, Gwalpara subdivision, along with his mother's name. Sona Khatun is a mother,
Stepmother.
stepmother.
Yes.
The name of the said Hassan Ali again is entered in the electoral roll of the same assembly constituency of the year 1970.
70. Yes.
Where is it? 70.
70 is at page 39, Lordship.
In
Relevant-
respect to the same village, Kathuri,
Yes, Lord.
along with his mother, Sona
Stepmother.
Khatun, stepmother, Sona Khatun. Similarly, again, their names again appear in the voter list of 1977 or which one?
77. Yes, 77.
77, 77, 79 in respect to same village of
Yeah.
Kathuri. Subsequently, the name of the petitioner appears along with his parents in the voter list of
2011, Lord.
2011 in the same village
Yes,
of
Lord.
Kathuri. And accordingly, and it has been also submitted that he had examined himself and his stepbrother to prove his legacy through the efforts at Hassan Ali. Having examined that the name of the Hassan Ali, the projected father, finds place in the voter list of 1966, 70 and subsequent voter list consistently in the same village, and also along with along with the petitioner himself in the subsequent voter list of
2000, his name is there in 2011,
2011 onwards.
2014.
We are of the view that the matter would
2017.
be we are of the view that petitioner has been able to establish a prima facie case in his favor for the purpose of grant of bail. Accordingly, the petitioner who is stated to be in detention in Jorhat detention camp may be released on bail during the pendency of this proceeding. However, on executing a bail bond of rupees 5,000 with security with like amount, he however will to the satisfaction of the retaining authority, that is the SP border
Jorhat.
Jorhat. He will accordingly appear, the SP border also will also record the iris and the fingerprints of the petitioner. Fingerprint. It also made clear that the petitioner will not leave station without informing the SP border here.
He is a native of Gwalpara. Case is in Jorhat. So he has to stay in Gwalpara, his own home district.
Okay.
And surety also will be from his
Okay.
home district.
Okay. It has been stated though he has been proceeded in Jorhat district, he is otherwise a permanent resident of Gwalpara.
Yes.
In that view of the matter, he will report to both, he will also report to SP border Gwalpara, who shall be in touch with the SP border Jorhat for the purpose of these proceedings. He shall not leave the district of Gwalpara without informing the SP border Gwalpara. With the above directions, full stop. List the matter
After 4 weeks.
after 4 weeks.
DPO price.
Like,
Daily list for admission, item number 1.
Jiten,
this is the sum up for the first
is a jail from the jail.
appeal.
This is the appeal preferred from the jail. And as such, nobody, and as such not represented. Accordingly, we propose to appoint
S. Roy is there.
S. Roy.
Yes.
You are a legal aid counsel?
No, I'm legally counsel, but
Le-
I'm not in the list of amicus.
No, but S. Roy means, S means full name?
Sanchita Roy.
Huh?
Sanchita Roy.
Sanchita Roy. Because sometimes what has happened, if you search right S. Roy, there will be so many S. Roy, we won't be able to find out who is this S. Roy.
Yes, they all come and check the file.
And they all come and check the file, all S. Roys. So only we'll allow only Sanchita Roy.
Yes.
Appoint Sanchita Roy to appear on behalf of the appellant. Call for the records. What is this convicted under what? Copy thou. 30. Murder of her mother-in-law.
Then the informant
Then informant is
is
Srimati Dipti Bora.
so daughter-in-law. Let the records come there. Daughter-in-law.
Since the particulars of the informant is not available, available now, after ascertaining the same, on receipt the records, notice be issued to the informant. This is the matter after receipt of the LCR by showing the name of Ms.
Sanchita Roy.
Sanchita Roy as counsel for the appellant.
Item number 2.
You also same, but here amicus is there.
Amicus already there, okay. Or Mr.
Are there?
Ardev, Laran amicus. Again, your full name, kindly give your full name because see,
Are there is only one, Lord Sir.
tomorrow there will be another Ardev, new Ardev. We don't know. You think that your name is unique. Nobody will have Ardev.
Lord Sir,
There are so many Last week, I had given certificate to 380 law students, graduates. 1 month. So in a year, there will be so many law students coming up and they will be enrolled as a lawyer. And you will rule out that there will not be any art dev. There may be art dev. So why you are hesitating to disclose your name?
Rajiv Dev, Lordship.
Rajiv Dev. That's such a wonderful name.
Yes.
Why you are hesitating? And Mr. Rajiv Dev, Planet Council for the Appellant. Appeal is admitted. Aage bhi na, earlier also. Appeal is admitted. Call for the record.
Informant is made a party here.
Informant and made a party. Let step be taken for issuing notice on respondent number 2, the informant. Lease after 4 weeks.
Lordship, obliged.
For orders, item number 3.
There's an office, don't you?
Met Your Honor. I am appointed as amicus curiae in this case. This matter has come up, but no record received. Okay.
Okay, no. Await for the records.
Obliged.
Yes.
Item number 4.
4. Yes. Records come.
Yeah, Lord, I have not received you, but one judgment have been received from this noble court. Your Lordship.
You have, records have not been received, no? So, records have not been yet received. Though notice was issued as long as long back on 22/12/2021. No, 3/12/21. No. Notice was issued on call for the record on 22/12/21. Call for a report from the concerned trial court, that is concerned sessions judge Boxa, as to why the records have not been transmitted yet. You are applying for whom?
She's also an
Huh?
She's also an APP.
You have to tell us, we don't know you. You have to, you have to disclose yourself, your identity. We only 2 APPs here in this court, Jahan and Burnali. Suddenly you are showing your appearance today for the first time. What is your name?
And that's Lordship, Nandita Das.
Nandita Das. You are also an APP? Okay. And also Ms. Nandita Das, Lanet APP for us.
Deep level.
Item number 5.
Suresh. Yes, you have received the paper book?
No, my lord,
Then-
I'm going to collect a paper book today itself.
Okay,
My lord,
We
maybe
have received.
posted for hearing.
okay. And Mr.
J. Sharma, my lord, Jyotirmoy Sharma.
Okay, J. Sharma, correct. Mr. Jyotirmoy Sharma. I would prefer to write the full names. Because it's
Yes,
always better.
my lord,
There are so many Sharmas also. J. Sharma,
Right.
Jyotirmoy Sharma.
Jyotirmoy
There
Sharma.
may be another Jyotirmoy Sharma also, but that will be rare. He may be. We are not ruling out, but there may be so many J. Sharmas. Because that's
Yes.
how we have difficulty in finding out. When the counsel is absent, find out who is this. We said, no, we don't know who is this J. Sharma. Maybe so and so, maybe so and so. So we do all speculations and okay. Mr. Jyotirmoy Sharma for Lane Council for the appellant. He has been submitted he has received the paper book today.
I will collect.
He will be collecting the paper. The paper books are ready. Paper will be furnished accordingly to Lane Council for the parties. Thereafter, the matter will be listed for hearing.
Obliged.
We have received.
You have received. Okay. R also means Nandita
Das.
Das. Learned APP.
Lordship, whether informant is
Hmm? Oh, yes, informant. Let us see the file, informant. Informant is a party in this case.
Yes, yes, my lord. That is, my lord, respondent number 2, Vidul Chutia.
Once we have made him a party, then he should be served notice. Did you take
was
notice?
Sent, my lord.
Huh?
Notice was sent.
Notice has been issued to respondent number 2, white memo number so and so by Resta post with AD. Notice was, we have taken steps. Who is this? Do you have any idea who is this informant? Does he belong to a?
He is the Adhakari, my lord.
Sorry?
He is the Adhakari.
No, but what is his status, financial status,
I don't
background?
know,
Do you have
my
any idea?
I
Huh?
don't know, my lord.
Hmm?
I don't know.
Projected pursuant brief is the one Mridul Chutia,
Chutia.
lost and Azhar. Night accused Mia came a wife, sit drawing room, serve him betel nut. Took out a pistol, fired a bullet.
Right.
Drawing room. They are not, they don't belong to perhaps a very poor family background. Appear to be well-to-do. Huh?
Maybe, my lord.
What maybe? You know, you are there in the scene. Or you are not there at all. You don't know.
His brother is
I have
killed.
not.
Appeal does, huh?
His brother is perhaps killed.
No, he is not better, my lord.
Huh?
Vidul Chutia is the relatives of the deceased, my lord.
Huh? Deceased brother,
Yes, yes.
his brother is killed.
But then, Nandita Das, can you make an form from your police whether this informant has been served notice or not?
We will take it.
Just ascertain so that he can be.
Yes,
so,
yes,
huh?
my lord. Yes.
Office note indicates that steps had been taken for service of notice upon respondent number 2 by Resta post with AD. However, there is nothing to indicate that the same has been served, nor the respondent number 2 is represented before us today. Under the circumstances, we request Nandita Das, learned PP, to ascertain from the police station, concerned police station, as to whether the informant had been served notice.
My lord.
Baki orders earlier, same order. Huh? Yes. You are certain because see, let them also appear. They may, if they are not interested, then there are other
My
issues.
lord, my
Yes.
lord. Obliged, my lord.
Item number 8,
Service report in respect of 3 is completed, I think.
IA for what?
I have for this delay, man.
How many days delay?
Delay 544 days.
Notice have been issued to respondent 2 and 3 by Resta post with AD.
Objection.
2 and 3, what is 2 and 3?
Oh, this is applicant's acquittal. Acha, acha,
Then they have to be served notice. If it is acquittal,
huh.
you must
The
ensure.
thing is that our main thing is that, my lord, yes, acquittal may go. And the challenge also is there, the compensation of the victim wife is given 50,000 in place of 2 lakhs. Man.
Okay.
This is a delay application.
Eh?
Notices, perhaps.
You see, that's why I am not raising now, no, just, my lord.
No, but then
If my lord, it is a widow, my lord, if she gets it, then she may not, my lord, go for appeal also further because this is the thing. So without this, we cannot make an appeal. This just I have expressed my this thing.
okay,
money.
but then, huh?
Kind
Of course, who has died? Who has died?
Husband, my lord, the young age man.
Husband died. Obviously, the widow should have been given how much was
50,000 is that government of Assam that notification is 2 lakhs. And the session judge has just awarded 50,000.
why 50,000?
In fact, it has been increased to 4-5 lakhs. 5 lakhs.
Then my lord, some more, if they're
5 lakhs.
she may not go to, my lord, to further proceeding of the appeal. If she gets something, my lord,
Blood
because
money, as we
by
say.
acquittal, that is up to your lordship, my lord. Because now it is in the case of 2016, my lord, not 2022. If she gets it, my lord, then it will be.
Well, this 5 lakh, the compensation is not going to be given by these acquitted people.
Government, my lord.
And even if they are convicted, they are not going to pay. And obviously, once they're acquitted, they will not pay. They have no liability.
Yes,
The government is liable.
yes, government is liable.
So
for
you
compensation.
take instruction in the meantime,
Ah.
while trying to serve notice on 2 and 3.
Yes, yes, my lord.
So already compensation is given by these.
But we are also concerned, why only 50,000?
that
You
is-
explain, why not 5 lakhs?
Yeah, that time perhaps it was not 5 lakhs,
Well, when was it? When was the compensation granted? Let us see.
2016.
2016. 2016, it was 4 lakhs.
2016 and 2016, what was the scheme at that time?
It was, I think.
Your lordship will find at page,
No, and 2012,
Huh.
2012, the notification, as per the notification 2012, debt is 2 lakhs.
2 lakhs.
yeah, oh,
And it was increased to 5 lakhs in 2019. Therefore,
So his case will come within, under the earlier notification.
early notification.
So it will be 2 lakhs. So 2 lakhs, the court has given 50,000. Would give to one, but
2 lakhs.
yes. Yes. I leave it to your lordship, my lord.
for rehabilitation of the dependents,
Yes,
she is the widowed wife.
But then, if we allow the appeal, assuming we allow the appeal, then appeal is a continuation of this
yes.
Mm.
Trial.
proceeding trial.
Yes.
In that case, maybe she will be entitled to a revised rate also. Because the rate is revised also, no? Because he also challenging the same. Of course, there is a slightly gray area.
Because procedural law, as we know, that will. be
Correct. This is not
applicable.
procedure. This is a
This-
beneficial
this is a
provision.
Beneficial legislation.
Yes.
This will, of course, that rigors of penal provisions to be applicable, only whatever.
But in the
is there.
meantime, while doing this, why not at least 2 lakhs, which is as per admittedly, undisputably, unless that, what is the requirement of C?
57A.
You have the 12, this notification with you. You have got a copy. Kindly, please give a, oh, it's on display. But then you give a copy to her. Huh? Because it will be, you have got a copy, 2012 notification.
I had one copy, but to now I think. Anyway, I can see, but I have one copy of 2019. 2012, I don't have.
12, give a copy, take a printout, give a copy, because it will be required by her every now and then. Huh? Give a copy. The victim compensation fund, there shall be constituted a fund, namely victim compensation, from which amount compensation so and so shall be paid. The government shall allot a separate budget. The fund shall be operated. Expenditure will be made. The state legal authority shall be responsible for maintaining the accounts, and the fund will be audited by the Accountant General Assam. Department release the fund to the state government, and the so and so. Accounts will be paid. Eligibility for compensation, this is important. Okay.
Yeah.
The victim or a dependent satisfying for crime shall be eligible. Loss injury sustained by victim or dependent should have caused substantial loss to income the family, making it difficult to meet their both ends without a financial aid, or has to be spent beyond his means. The victim dependents report to the crime to the police officer and so. The victim cooperates with the police and prosecution during investigation. Where the perpetrator is so not traceable or goes after trial, but the victim is identifiable and a victim has to be rehabilitated physically and mentally, such victim may also apply for granting under subsection so and so. Procedure. whenever recommendation is made by the court on application by a victim, so and so, respect shall examine the case, verify the contents of the claim with regard to the loss or injury. Compensation shall be paid subject to condition if the trial court, while passing the judgment later on, orders the accused persons to pay any amount by way of compensation, so and so, the victim shall remit an amount of compensation. Now,
That
for our
is why-
purpose, 4 and 5 are important.
Yes.
Now, of course, the condition is that it should have led to loss of substantial loss.
Mm,
It should have led to substantial loss to the income of the family.
mm.
What is their income? What is the means of livelihood for
Those
this
things
lady?
did not bring in the record, madam.
So what we can do is that
Now,
we can,
only
in the
that-
meantime,
that from evidence on record, it appears the deceased died leaving behind his wife and mother. The deceased was just young, mother lost a young son. It is evident that financial condition of the deceased was not so bad. The loss of mother and wife of the deceased cannot be compensated in terms of money. This is the findings of that session judgment.
Not so bad.
This is his own, because the trial on the whether the victim is killed by the accused or not. That was the trial, madam. I don't think these things they have. It is the lawyer or from their behalf it was submitted before. This is a court own things. Is whatever. So practically, I know, madam. I don't think that they will submit or they will put evidence in that manner that our income is so that so and so, so and so, so and so. These are in the findings of
what we will do is that while considering this application, since death has occurred, and it appears that no such detailed inquiry was conducted.
It is never made.
So we'll ask the, which district is that?
Gulaghat, madam.
So we'll ask the Golaghat Legal District Legal Service Authority to make an inquiry as to whether the present appellant or the victims fulfill the conditions as provided under section para 4 and 5.
Yes, they'll go
And
find
at
out
that
whether-
time, the amount payable was 2 lakhs.
Mm.
So if it is found that they fulfill, they may be given 2 lakhs. Then we'll see in the meantime what happens in the as far as merit is concerned.
Or maybe some amount is already given to them.
Subject to, of
2,000.
course, subject to,
Mm.
they will be entitled, if they are entitled to 2 lakhs, may be given minus which have been already
Yes, ma'am.
given.
Let a legal service authority find out that.
Okay. However, it has been submitted by Mr.
He should have.
B. Sinha, learned counsel for the appellant, that he is also aggrieved by awarding of only 50,000.
Right.
Where the judgment, let us see the judgment.
Yes, the appeal, my lord, page 16. madam.
Page 16. Also aggrieved by the
Para
fact that
21.
the learned trial court had
Para 21.
granted only 50 lakhs,
50,000.
50,000 for her rehabilitation, though it was urged before the court that she would be entitled to 2 lakhs in terms of the notification dated notification number PLA 757.
2 lakh is the maximum actually.
Now, what is this PLA 524
Yeah,
215?
this is the court office phone, my lord. You don't have that.
As per notification issued by the government
There is
of
no,
Assam in that regard.
there is no date, my lord.
It has been submitted that because of the death of the appellant's son in the hands of the no sir, not appellant, informant's son. Informant's son,
Informant.
appellant's son. Now you are the appellant.
Now appellant.
Appellant's son in the hands of the accused. She not only suffered serious mental trauma, but also was subjected to financial hardships as the deceased was supporting her. We have also, having perused the order of the learned trial court, granting only 50 lakhs,
50,000.
50,000.
There's another notification, 14, their debt, their age, 40 years, below 40 years is 3 lakhs.
2014, no,
Yes,
trial,
yeah.
and this trial was,
16.
okay, so, okay, then we'll refer to this. There is another notification issued in 2014. It has been enhanced to 3 lakhs if the death of the person is below 40 years. Okay, then we'll refer, then maybe.
Yes.
Okay.
There is another problem here. This is an application for delay condonation. Lordship is passing.
Doesn't
the-
matter,
Even this is not admitted, this.
doesn't matter.
pending.
We are exercising our own powers.
Okay,
We will not
that
wait
can be
for
done.
these formalities of serving notice and these others. If certain facts are before us, undisputed facts,
Mm.
is about a delay. So
Mhm.
we'll ask the district authority to verify it.
Mm.
This
Yeah,
will
yeah,
go on,
yes,
all these issues of, you see, limitation, this and that. We may dismiss his appeal also on merit, that there is no reason to interfere with the finding of the learned trial court, acquitting them. But this will be different.
This
This
will
will
be
not,
different.
this will independent of the claim of compensation.
Already-
Compensation is, the payment for compensation is not dependent on the guilt of the accused. It is the responsibility of the state
Yes.
to give this compensation the moment the death occurs, subject to fulfillment of certain conditions that he has reported, the informant has or the dependent had cooperated with that. That is what we only see that.
Yes.
Therefore, though it may not be, as you say correctly, that this is not, but then we, because otherwise it will lead to delay.
Yes.
What is the purpose of passing this order of 10 years? By the time this lady also may go somewhere else, beyond
Yeah,
return.
Take care of
Huh?
restitution and all that. So this is very important.
So we'll not wait for the formalities to be completed, because this will not come in that way. Because this is a very independent,
Already married, everything.
yes.
Then even with some notification, also again 2 lakhs, later date. They're taking 2 lakhs.
We did nothing.
We said, okay, 2 lakhs. In exercise, government is pleased to amend the schedule by fixing acid attack. Oh, this is as per the government of India, that NALSA, that compensation, no? And then because acid attack was given a lot of family. Acid will get 3 lakhs, he will get the acid,
Yeah.
3 lakhs, but this fellow will die, but he will get only 2 lakhs. Anyway, that. So this was more When this matter was taken up, it has been submitted by Mr. B.C., Learned Counsel for the appellant, that there is yet another issue which is being raised in the appeal. That is the quantum of compensation. The learned trial court, while passing the impugned judgment, held that from the evidence on record, it appears that the deceased died leaving behind him, his wife and mother, and he was young. Thus, the mother lost a young son. It was also observed that it is evident that financial condition of the deceased was not so bad. However, the loss of mother and wife of the deceased cannot be compensation in terms of money. In this case, in the considered view of the court, the wife of the accused is the worst sufferer and needs financial assistance for rehabilitation. And as per the Assam Victim Compensation Scheme Wide Notification Number PLA 524/2015/16, the one, this one, 2 lakhs, this one, I think, yes. The wife of the deceased is entitled to get a compensation of 2 lakhs. However, the trial court, considering the nature of the case, took the view that an amount of ₹50,000 will be just for her rehabilitation, and accordingly recommended aforesaid amount of compensation to be awarded by the DLSA Golaghat in exercise of the power conferred under section 357A(2) of the CRPC to the wife of the deceased, Mrs. Sajida Begum, wife of Tawfiq Ali of village Hatia Khawa, PS Golaghat, district Golaghat, Assam. It has been submitted by Mr. B. Singh, though this plea is also part of the appeal, which is yet to be admitted, inasmuch as the application for condonation of delay is yet to be allowed by this court. It has been urged before us that irrespective of the outcome of the application for condonation, or for that matter, the appeal challenging the acquittal of the accused, payment of compensation is an independent proceeding, not related with the culpability or guilt of the accused. And accordingly, it has been submitted that the issue relating to compensation may be considered at this stage, even without giving any notice, serving any notice to the accused who have been acquitted, and it will suffice if the state is heard in this regard. Next, Peda. What is your view in this, Jahan?
In fact, 357A is when somebody dies because of the crime committed. So lordship has to first decide whether it is committed. And subject to what condition, subject to correction. I'll just read out 357A1. Every state government in coordination with the state government shall prepare a scheme as a result of the crime. So that has to be as a result of some crime. So now they are now they are acquitted.
Even in acquittal also in 2012, procedure for even if acquitted also compensation can be granted.
The
We'll come
words
to that.
used,
Yes.
used are dependents who have suffered loss or injury as a result of the crime and who require rehabilitation. So
See,
here
unless,
the
correct. If you say it is suicide,
Oh, yes.
They said if he has committed suicide, then no crime was committed by anybody else.
Yes.
But is it a case of suicide here? Let us see.
No, here the appellants are acquitted.
Acquitted, but on what?
Oh,
On
yes.
acquitted benefit of doubt?
Oh, then somebody else must have done it.
Ah,
This is homicidal death, of course.
ah.
the
So
PM
let us see,
report-
that's why if it is a homicidal death, then because the failure of the state to prosecute the correct guilty person, why should he be denied the compensation?
Yes.
So we will go to that. When you go through that judgment,
Mhm,
does it indicate it is a homicide?
mm.
It
Because
does
the
indicate.
PM report will show
Mm.
how did she die.
You see, go through it, the judgment. You don't have a copy of this.
I don't know. I don't
Oh, you
know.
don't have a copy of this?
They did not somehow find out.
Okay.
They have no copy.
Here, eligibility there, where the perpetrator
Just
of the
seeking
crime is not traceable or goes unpunished after trial, but the victim is identified, but goes unpunished. Victim is unpunished.
That's very clear. Because,
See,
yes.
you have you given a copy of this scheme to?
No, it should
Have you got a copy of the scheme?
Yes, clear.
Come to see para 4.
Eligibility.
Para 4 and clause 4.
Hmm.
Sub
When
para
the
4,
perpetrator of heinous crime is not traceable
not
or
traceable.
goes unpunished,
Ah,
but the victim is identifiable and the victim has to be rehabilitated physically.
see,
Now here, if we go to the report of the doctor,
yes, let us see. Yes, go through that. Yes,
so
yes.
Rajiv Fukan PW11, he said, of course, there are so many injuries.
Is it homicidal in nature?
Mhm.
Just see.
It is said the injuries are by blunt weapon. All the changes are antemortem in nature. Then
Yes.
it is by blunt weapon. Postmortem is less than 48 hours. All findings are antemortem. Postmortem was done within 24 hours. There is presence of so and so, grievous in nature. In my opinion, a cause of death is due to shock and hemorrhage as a result of the injury. So this is homicidal death. Yes.
Yes. So what are the injuries? Presence of deep blue colored seen in the left chest.
Mm,
Deep reddish black abrasion on the right chest.
mm.
Presence of all so and so. There is presence of deep blue fracture on the rib. Right, Lotra. And
So chest,
and
chest.
on what ground they were acquitted? Kindly see, is it because they were not able to prove beyond reasonable doubt? Or
There is
what?
a thing.
Huh?
Yes, man.
What is that sentence?
That is your
Paragraph
lordship will
17,
find.
18.
I find that there is no direct evidence to link the accused for causing the death of the
Hmm.
deceased. I find that the entire prosecution lies on evidence PW and PW, but I find that evidence is not free from doubt.
Injuries may be sustained in a motor accident.
He was,
There is suspected. There is a submission of PP, madam, but not considered by the court.
PW 12, investigation confirmed the P did not state before him that while the deceased was getting into vehicle for taking him to Jorhat, the deceased informed him that his accused assaulted him. PW 5 further stated on the day of burying ceremony of the deceased, one Junti Ali informed that while he was coming by driving a vehicle, he found a deceased being assaulted. And while he tried to take out the deceased, the accused person restrained him by threatening him. The court, to arrive at a right decision, the ends of justice examines as Junti Ali as court, but the evidence of Junti has not at all supported evidence. His evidence totally silent that he saw the accused person, a PO, or assaulting the deceased. From the evidence of PW, it appears that one Dadao Bora informed her that he saw the accused persons. The records have been called over, requisition, no. In this case,
No, not yet. This only delay.
okay, delay is there. Exhibit 5 is an inquest which shows that deceased sustained injuries from road and traffic accident. Oh, then
Then
if it's a road and traffic accident, then you go to MB Act, motor vehicle, then there is a different. Under the circumstances, though, we have not yet, under circumstances, full stop, next para. There is also a recording observation by the learned trial court that Exhibit 5, which is an inquest report, indicates that the deceased sustained injuries from road and traffic accident, full stop. We are of the view that accordingly, we are of the view that unless the deceased died due to homicide, the death of unless the death was due to homicide, unless the death was homicide in nature, not accidental. Comma. Therefore, no, actually, considering that in view of the above evidence reflected, in view of the observation of the learned trial court, we have the view that we will like to examine the record even for the purpose of considering the grant of compensation. Accordingly, let the record be called forth. We'll call for the records then.
We have to be held.
It has to be victim, see, because if it is a road accident, then.
No,
it
it's not,
changes.
actually not road accident.
Correct, but then see, the observation is there.
Yeah,
Inquest
yeah.
report says.
He was
so therefore-
going at night, my lord, from the.
So
work.
we'll examine only for the,
Yes.
not to ascertain the guilt or otherwise of the accused.
Yes.
That will do. If we condone your delay, then we'll hear on merit, on culpability of the accused. But we want to examine for a limited purpose. Because when you say that, yes, he's a victim of assault, and it was homicide, and they were responsible.
Yes.
Because the rules also says that where the perpetrator of heinous crime is not traceable. So it is not necessary that the culprit must be apprehended. He may be untraceable also, but that does not debar you from claiming. But we have to understand how he died. Okay, then we'll call for the records for the link. LCR from the court of
Session Judge Golaghat.
Session Judge Golaghat.
Obliged.
Item number 9.
May it please your lordship.
I is pending, we have filed our objection.
Yes, 9.
Yes. I is pending.
I for what?
Suspension of sentence, my lord.
Suspension of
And
sentence.
bail, my lord.
Yes,
We have not
have
received a
you,
copy of the-
Yes, I filed my copy, I filed my objection, it's
You
on record.
We have not
So-
received, my lord.
Without serving them a copy, we were.
you have not got a
No, my
objection?
lord.
Okay, then you get a
Yes,
copy then.
yes, my lord.
I'll give him a copy.
Miss, even though Miss Jahan, learned APP, submits that objection has been filed, Mr.
Sarfaraz Nawaz. S. Nawaz.
Shashwat,
Sarfaraz Nawaz.
Sarfaraz Nawaz.
Sarfaraz Nawaz submits that he has not received a copy of the same. This is a matter of the vacation. A copy may be furnished
Much
to
obliged.
Mr. Sarfaraz.
Item number 10.
May it please your lordship.
Topeshwar Rava. Yes, what is this?
Lordship, may this matter be passed over for a time.
What is this matter about?
Tribunal appeal.
Criminal appeal.
My lord, in this case, I have been engaged as an amicus curiae,
Okay,
and the
I
private,
has
and
been filed.
they also appear file
Yeah,
an
just-
IA, by private.
just a minute.
That's-
Just a minute, we'll see. This is an appeal from jail. Appeal is admitted. LCR be Mrs. Ezra appoint amicus, Jahan prepare book, Roy is in the pen, maybe case suspended. His opinion that the applicant may have a case, she may make an application. In case a new language wishes to intervene. Could you interact with the this Sonitpur? In
No.
case the newly engaged amicus wishes to interact with the newly engaged, that means let us see the history of this order. No. In case the appellant higher Sonitpur will render necessary, could you contact this appellant? No.
One of the relative of the accused.
Sorry?
One of the relative of the accused has contacted me. But,
Okay.
Papers are not handed over to me.
In the meantime, they have engaged you. What is your name?
Singh Burwa.
Huh?
Singh Burwa. S. Burwa.
Sen Barua.
S. Purva. Then
Spelling Sen.
Spelling.
Sen what?
SENG.
SENG. Seng.
Seng Barua.
Okay, Seng Barua. So you have been engaged by the party.
there is only one appellate. He is there. Amicus is also there.
No problem. Amicus
Yes,
will
of course.
continue. If you want to have Mr. Singh also, no problem. Most welcome. You continue, Roy also.
And this I is for the first time. I mean, it has come up for the first time. It has been filed very recently. I'll find my.
This IS filed by whom?
By
Mr.
the
Konok
appellant.
Sharma S. Barua.
Hmm.
Okay,
I'll file my objection to this.
okay. And Mr. Sen Barua, Seng Barua, learned counsel, learned applicant. Issue notice. Ms. But this is 302.
Hmm.
Anthony Bhengra. Notice has to be served also. Take steps.
Hmm.
Applicant to take step for service upon respondent number 2, Anthony Bhengra by registrar post with AG. Full stop. Since Ms. S. Roy, sorry, I couldn't. Sanchita Roy.
Sanchita.
sorry. However, since Sanchita Roy had been already appointed as an amicus in this case prior to the engagement of the new set of counsel, she will also continue to assist this court as amicus in this case. List a matter of the 4 weeks. IA.
Item number 11.
11, I'm yet to file my objection. Somehow I missed. The rules are correct.
Page
And
number
whether
29, my
this,
lord.
uh,
Page number 29.
Lordship may give me
Alice, my
5,
lord.
6, 4, 5, no, anyway, it will be after vacation then. Immediately.
You have been
after the-
convicted under which section?
My lord.
You have been
Three-
convicted
302,
under?
my lord.
Huh?
302.
302.
Yes, my lord. Can you see, my lord, page 29, my lord? The dying declaration, my lord. Page 29,
3. Page 20,
9 of IA, my lord.
29 of the IA. Yes.
At about 9:30 PM, fire somehow caught me while I was preparing food in the oven. I was brought to Nemkar Hospital, Guwahati, my lord. Is there, my lord, statement?
Mamuni Bishwas.
My wife, my lord.
Fire somehow caught me while I was preparing food in the oven. I was brought to Nemkar Hospital. This aspect was considered by the learned trial court. What did this learned trial court say about this dying declaration?
It's at page, my lord, in my lord. The judgment, my lord. They have not, my lord, considered this, my lord. At page, my lord, page 20. Of the, my lord, appeal, my lord, my appeal.
Anyway, what we can do, Jahan, you go through this judgment tomorrow, day after tomorrow, at least go through the judgment, even if you don't find, because he said at about 9:30 PM, fire somehow caught me while I was preparing for food in oven.
Yes. This shows that it is an accidental.
Appears to be.
So.
Unless the husband has put some very inflammable
Mhm.
article in the oven, near the oven,
No, no, my,
and nothing like that.
no, no.
Can you go
Yes,
through
yes,
this
I'll just go to the judgment tomorrow. Lordship.
tomorrow? Huh? Tomorrow.
Supplement.
Tomorrow, man.
Tomorrow. Let the matter be listed tomorrow.
Item number 12.
Santosh.
Please, your lordship, I am appearing for the delay. This is the continuation petition. Delay is only 114 days.
140 days delay.
114, 114.
114.
Yes, notice.
Huh?
Notice.
Notice because
So is also there.
Jahan says if it is 100 more than a century notice, she has evolved a principle criteria of her own. 100
Self-made.
century, above century notice.
No.
Below century 99 no problem. 101 notice.
376 is there, POXO is there.
Yes.
Let the notice go to the informant as well.
Informant also. Her Ms.
S. Chakravarti.
S. Chakravarti, Nana counsel for the applicant.
Appointed as a legal aid counsel.
Oh, okay. Legal aid counsel. Let notice be issued to respondent, but Ms. Jahan appears for APP appears for the state, respondent number 1 state. Let notice be issued to respondent number 2, the informant and mother of the prosecutrix.
Yes.
Mother of the prosecutrix.
Mother.
By rest of post with AD. List after 4 weeks.
No problem.
Supplementary list for this item number 15.
Amir Hassan.
Oh, Amir. Amir Hassan, yes, I got.
What is this Amir Hassan?
On the last occasion, I was supposed to, Lordship has ordered me to get the instruction about his health condition. The accused, Amir Hassan's health condition. I got a report. And Lordship can see it in the display.
IFO what? Bail.
I have for bail, my lord. I have for bail, and on last occasion, my lord, I submitted it along with the bail. There, I submitted that the health condition of Amir Hassan is not so good. So my lord has called for one report, and along with it, the bail is to be heard.
Yes, what is his condition?
That report, of course, not very grave. It
With
seems.
due honor, I would like to state that MD Amir
Hassan
Hussain
complained of pain.
complained
in
of pain, abdomen with loss of appetite and general weakness on 23/9/22. Consequently, he was referred to Lakhimpur Medical College, from which he is undergoing treatment and recovering. Very good news.
He is
Recovering,
hyper-
madam.
Yes,
We are
yeah.
happy. Recovering.
And-
He is also
Tensive,
hypertensive,
BP is so and so.
pulse so and so,
Pulse.
for which he is undergoing medicine and medication. Undertaking. At the time of examination, his vitals are stable.
My lord, on that day, he was taken to hospital, actually, on that day. I mean, so this report, I think, basically of that day. my lord.
Correct. That means the hospital is taking
My
care.
lord, that time, but my lord, I'll go for the IA, my lord. With, there is an IA also, my lord has also asked for this report also. Because since the jail authorities have given on that day, but as.
But you said that his condition is very precarious. He's, anything may happen.
Yes,
But that very
my lord.
dismal picture,
This report reflects that day of that day, I feel so, my lord.
they opted.
Means of that day, of condition of that.
No, they are also very good. They are immediately concerned and they are giving you treatment.
I have submitted, they have taken me to hospital on that day.
Then
But my lord, his condition is not good as per my instructions of my client, my lord. That is, I cannot visit, my lord. As my instructions. from the
I have to
hospital.
go by the medical doctor, no medicine,
Yes,
medical health and officer, district jail, hospital, not Lakhimpur. He has given in his own writing. So it does not
my
disclose
lord,
a very
180 by 80 is BP.
BP.
Yes, my lord,
Yes, 180 by 80. Yes. 180 or 130?
80 by.
No, it can be
180,
180.
30.
130,
80,
madam, 180.
180.
Oh, 180. Okay, 180 by 80.
He is aged.
He's also
88.
hyper, okay. High BP, correct.
180/80 on that day.
That is why he's taking care, they're
My-
taking care.
As per my information, my lord, now only I'll go on my client's instructions, my lord. As per his instruction, he said all he used to be ill all the time, and for me, he's most of the time referred to hospital and all those things, and he's not well. This is my.
No, we understand, we understand. But
And
then,
in
but
the
then the jail authority also taking care of
That-
it.
that is there.
Because they said at the time of examination, his vitals are stable.
Stable 180/80. Well, it's my lord, it can lead to stroke also 180/80 is not so normal. My lord,
See,
contradictory.
if he has a stroke, then see, you'll be in difficulty.
180/80.
He is on the constant medical attention.
Ah. One-
Okay.
He is 58 years, no? He is around 58 years.
How old is he? How
My
old is
lord,
he?
as per the petition, my lord, 68.
60.
68.
Or perhaps in
I would
2010.
say, yes,
66, 65, huh? What is it? 68 years.
These people. my
Okay,
lord,
68, 69.
As per information is more. These village people, this age and all those are 68, but as per client submission is more than 72. His son, this brother is 55, sons are 35. His wife is 68.
I see, is a 302.
My lord 302, 326.
And what role this old man had played?
Yes, my lord, my lord, on last occasion, I made a submission, my lord might remember, they are convicted under 302, 326 and 149. My lord, my submission on last occasion was that my lord is supposed to hear today that part. It doesn't fall under the category of 149. If the 149 goes, the role is that he has beaten one accused at his by stick at his head and another accused in his leg. Is only the position.
So this Amir Hussain used stick.
Use stick, lathi or with stick, he has.
Then there's a specific role has been assigned to
Yes,
him. He's
assigned.
the one old man. He has the strength to
This
lift a stick and
this
hit
is-
somebody, and
this
suddenly he falls in
incident is of my lord. Incident is of 2010.
2010.
Then he was 58.
At that time, he was young. He was
58,
vibrant,
yes, yes.
As
and
per-
he could hit the person with a stick.
stick one blow in the
On
head,
where?
on
Head,
head,
head.
one
On the head also.
Head.
and one.
If he had hit on the leg, perhaps we could have given some.
No, no, my
But
lord,
now
that
you are the one who hit him on the head.
My lord, this one, there are two eyewitness. As PW3 stated he hit on head and PW4 stated he hit on leg. Not that is. PW3 stated he hit on the leg head and PW4 stated it hit on the leg. One step. Two eyewitnesses and they have stated in that.
And what witness? One eyewitness is on the head.
And
Two eyewitnesses.
another, there are two eyewitness in total. One said in head, one in leg.
So 50-50. Cancel. Huh?
And my
In
lord,
hand.
the submission is with regard to 149 also. There is one another accused, Idris Ali. The only role my lord, I take your lordship, my lord may only do one line.
The
PW
paper book has been prepared or what?
Yes.
Paper has been prepared.
It's
Let us
ready.
see your
Yes, my
evidence
lord.
that
Page 11 of the paper book.
page 11.
Page 11 of the paper book.
PW2.
PW.
Who's this Abdul Qudus? Who is this?
He is the informant.
He's the informant. What
He's
does he
the-
say?
What, my lord?
I saw the accused. Then I saw accused Idris Ali was plowing
Yes, my lord, this one.
the land belonging to accused Amir Hussain. Amir Hassan.
The rest of the accused persons were sitting on the bank of their pond.
And the rest was sitting on the bank of the pond.
My lord,
At that time, I went to open my shop. Then why is it assault?
the assault, my lord, this is with regard to Idris Ali. With
Then?
regard to Idris Ali, he was taken under section 149. My lord,
No,
this
no,
is
no.
the only
We'll come to that law,
yes.
but
My
we
lord,
just want to know the facts,
Oh,
evidence.
My lord,
So hurting now, this Amir Hassan,
Yes.
now what role he played?
yes,
Amir
I
Hassan,
take your lordship to PW3.
PW3. Let us see.
My lord, I have to read in total then, or my lord only wanted the Amir Hassan part.
PW3.
Yes. my lord, one.
Yes.
In total, my lord, only Amir Hassan, if Amir Hassan, my lord, the fifth line at page 17.
Page 7, fifth
Page
line.
Fifth line. At the time when
At the time when he was coming, accused Amir
Amir
Hassan
Hassan,
hit my
my
father
father
on his head with a
the
lathi. Okay.
My father
Fell down the ground. Okay.
This is the
PW3. Then
Then I take your lordship to PW 4. Page 21, the third line. Continuation of second line, page 21.
my husband, Amir Ali, arrived there and then accused Amir Hassan hit him on his leg. Accused Rahul Amin hit my husband on his head
My lord,
and waist.
Amir Hassan role restricted to these two points.
Meanwhile, my son accused hit him on the neck.
With regard to Amir Hassan, these are the two statements. With PW3 stated on the head with a lathi, PW4 stated on his leg.
But nevertheless, he hit.
My lord, that is there as per the version of PW3 and 4
He is a lathi.
with a lathi. It's 320. My lord, in you, my lord, that is why I was emphasizing on 149. If 149 goes, it is as under 302, 149 was there. So my lord, taken together. If 149 is not there, my lord, I can establish that. Then it is charge system under 326 and 302. And with that, as per the deposition, the 326 is also, my lord, not there. So my lord, it will fall under 323 or 4. So 149 is minor, and 149 only came with one word. That is why I was emphasizing on PW, my lords. The deposition of PW2 at page 11.
Page 11, yes.
My lord, the second paragraph. May I read
Yes,
it?
yes.
At that time, I was freshening up at the courtyard and of our house after getting up. Then I saw that accused Idris Ali was plowing the land belonging to accused Amir Hassan, and the rest of the accused persons were sitting on the bank of their pond. So only this statement and the learned court, my lord, I take your lordship to the paper book at page 79 of the judgment. The third paragraph, my lord, page 79. The third paragraph, fifth line. My lord, may I read? The fact that the accused Idris Ali was present at the place of occurrence as a part of the unlawful assembly was not disputed by the defense, even if no overt act was attributed to him. The learned court considered the plowing of the land of one person and the other person sitting on the pond, sitting at the bank of the pond. The learned court considered these to be together, the Idris Ali and the other persons together. So, my lord, as per the deposition, my lord, and even if considered, my lord, it is admitted that Idris Ali was plowing the land. The other persons were sitting on the bank of the pond. And as per the sketch map also, there is difference. So, my lord, how 149 came to Idris Ali? He was present there, but his intention, he was plowing the land at that time. And the other persons were there. There's even no common object was there. So 149 was taken only on that statement, my lord. And my lord, I have gone through the other deposition. Yeah, my lord, one more submission to be fair, I will make. My lord, one PW2 and 3 in their 164 statement, but they have not stated that in their deposition while giving deposition. PW.
What is the FIR?
FIR, take your lordship to page 2. It was page 2 of the paper book, my lord. Humble submission, my lord, Mary. Page 2.
How did he die? That death, the cause of death of
two persons. One was by Degar, one was dead, and the other person was by step on the back by Dao.
Dao. And who are the persons who had used this Dao sharp weapon?
They are the, my lord, the petitioners before your lordship, one Ruhul Amin and one Nazimuddin. They are the sons of
Ruhul Amin and
Nazimuddin, as per the versions of PW.
Nazimuddin.
Yes, my lord.
Nazimuddin.
My lord. Hello, these are the sons, they are the sons of Amir Hassan. They are the sons of Amir Hassan, and as per the version, PW3 and 4.
No, son of Amir Hassan. Appellant says.
And my lord.
So, as far as Amir Hassan is concerned,
My lord.
there is evidence that he hit, whether
He
head or
did,
leg.
My lord.
Okay. And Idris Ali, no. According to you, there is no role played by Idris.
No,
No role at all.
no role at all as for my.
Idris Ali, what was he doing there? Idris Ali?
The land
He was only plowing.
plowing the land as per the position of PW2.
PW2.
PW2. At page 11.
At the time I was freshing, I saw that accused Idris Ali was plowing the land belonging to
He's doing.
you.
Accused
At that
Amir
time followed me, rent quarrel had taken. Then I saw my step mother, Khatun, coming and holding on. My mother told me that accused had killed my father. I saw my brother already died, but father alive. My younger father also lying in jail. I took my steps to ensure my father. But it is not a big mob, no? Only 3-4 of you. They knew, yeah. They said, how dare you tilt, plow or land? Maro. So it's not a mob, the big mob that is difficult one.
It's
They are
not-
there.
No, my lord, the fact of the case was that Idris Ali was plowing the land. The other persons were on the side of the
Sitting. They
pond.
were also sitting.
No, on the
Pond,
end of the
pond.
pond, one was in their own land plowing the land.
Uh,
So thereafter, as per the version, these two persons that died, they came there and there was some dispute and then. But
obviously,
with
there was a
regard to-
dispute.
My lord, with regard to Idris Ali, other than this, there is no statement all over.
So apart from what they know,
No,
I did not state that when the accused Idris Ali was plowing the land, the rest was sitting. Now you mean to say apart from this plowing, there is no role, there is nothing has been attributed to him.
No, not even a single.
PW3. Yes, what do you say about this Idris Ali?
Yes, Idris Ali, even I don't find any overt on his part,
Ah,
but 149 is very much there.
correct.
149 lordship knows it has to be gauged from the conduct of the parties. Now here, Idris Ali was plowing the informant's land. And then when the son of the deceased was crossing the land, he asked Idris Ali, why are you plowing our land? Then Idris Ali did not say anything. Instantly, the other people who were sitting beside, they started assaulting Mukhlis.
So
Son of-
Idris Ali came to the place of occurrence to plow only.
But
Is Idris Ali related to this Amir Hussain? No.
they asked.
Idris Ali is engaged
Hmm.
apparently by this
No,
Amir Hassan.
Amir Hassan's son, perhaps.
No,
Idris.
No. See, Idris Ali now, see, the accuser Amir Hassan, the owner of the land.
Yes.
Then 2, Rahul Amin. Then number 4, 3 Rahul Amin and number 4 is Nizamuddin.
Huh.
And number 5, Rohima Khatun.
Mm.
So all these accused
Mm.
are related except Idris.
Idris.
Idris appears to be not related to them. Appears
No,
to be a
if he is-
person who was engaged by this Amir Hassan and his family for plowing.
No, if that is the case, he has.
No, he was plowing, so he also jhagda, them keep on jhagda.
No,
So many jhagda happening
yes.
around the world.
If
He's
he's-
engaged to
Ah.
plow.
If he's simply a worker, then that
Ah,
should be different.
That's what we are saying.
But
Yes.
he's son of late Qasim Ali.
And who is this Qasim Ali?
Because
Is he related to Amir Hassan?
Qasim Ali,
As per my lord.
No, obviously he's a son of somebody, but question is whether he is related to this accused, other accused.
Son of late Umaid Ali. As per 105 the search sheet. Search sheet, Amir Hassan is son of late Umaid Ali. Idris Ali is son of late Qasim Ali, son of another person.
that Qasim Ali's relation with Amir Hassan has to be seen. That of course.
So if he is from the same household, though, then one can understand that.
Yes.
Otherwise, if he is just plowing, they may say, "Hey, Idris, come. We'll give you money, you plow our
But
land."
nowhere they have said that.
If they
Idris
so,
Ali-
just because he is plowing the land, you
Ah.
cannot implicate him unless there is some overt act,
Overtake not necessary, but if they were relative.
relative also.
Ah,
Correct?
But
Relative or came as a gang to do
Ah,
that. You know,
yes,
if they
ah.
come, planned manner, premeditation, meeting of mind, then
Then-
okay,
then
we'll
of
do.
course.
And why should he do if he's not related? Why should he poke his neck?
No, he is, of course, he is plowing the land of the informant.
Hmm.
He might be a worker, but then that has to be again seen. I have not.
That's why the Idris Ali.
PW4 said he was
Use
plowing
Therefore,
on the land.
therefore, Idris Ali, the role of Idris Ali is only plowing the land. Apart from plowing the land, how is he related with the other accused?
Hmm.
Son we can understand. If the father is affected, the son will come
But
to rescue.
that
So you can always expect the son to,
Yes.
whatever it is, right, wrong, they will always come to the help of the father.
Mm.
But why should Idris Ali come? Why should Idris Ali get involved in this incident when he has nothing except for plowing?
if he's simply a worker, then of course
Yes,
you have no.
is he a worker? Yeah, what do you say?
See whether he, that's instructions I have not taken worker, but in village.
No, forget your instruction, you have to go by the evidence.
Relation is known. By the whole, no relation is known between Idris Ali and Amir Hassan. And 105 search it says father of different person.
None of the witnesses have said.
Then
also who
perhaps
was-
Idris Ali may be entitled to bail in that case.
Let me just check out once more the deposition.
Check it.
Uh,
What is the role of
yes.
Idris Ali apart from plowing?
Only plowing. One
Yes.
said, one did not say anything. One said.
One
he
is actually
came out-
an eyewitness. One of the eyewitness. Here it.
In this hacking business, hitting business, Idris is not shown anywhere.
Mm,
Is Amir Hassan hitting his father on lathi,
Yes.
father fell down, then accused Rahul Amin hacked my father on his buttock with a dowel.
That is.
Amir hit me on my head. Amir Hussain, so he hit, accused Amir Hussain. He hit his father and him, madam.
My
Not
lord,
only
it-
this
no,
old man,
my lord,
he
this
hit
it was-
also
my lord, this
PW3,
it-
Sheikh Farid.
My lord, that was, my lord, this is the PW3. My lord, with PW3, during the whole process, my lord submitted PW2. My lord, one submitted, PW2 stated PW3 came running to him with head injury. Then medical was done. During the due course, it was observed by the learned court that PW3 and 4, there was no injury at all.
No, let us see. No
Yes,
injury.
yes, my lord, PW, I take your
Then accused Amir Hussain hit me on my head. I became senseless and fell down there. 15 minutes I regained.
Page 80, my lord.
Eh?
Page 80 of the judgment.
80.
My lord, page 80, may I read the first paragraph, second line, last second line. But there is no any medical evidence on record to support such injury that PW 3 and 4 have sustained.
Page 80. Para?
Page 80, first paragraph, the fifth line.
Oh.
But there is no any medical evidence on record to support such injury that PW 3 and 4 has sustained at the time of occurrence. So, the injury of PW 3, the whole case is
They may not see, they may not go for medical and village. What about the IO says? What does IO say? Did he find injury? Huh? IO evidence. In village, everybody doesn't rush to, they don't know, oh, let us prepare for a case now. So we must keep all the evidence intact.
No, my lord, here.
They don't know they are. Do you think that the moment there is a jhagra, they'll immediately rush to the hospital, get an injury so that it can be used in the subsequent criminal proceeding?
No, my lord, in this case, they stated that is that I found in this case.
Maybe the doc, they have lost it, maybe the certificate. Anyway, what does IO say? IO. Did IO find
Page
them injured?
28, page 28.
Page 28. I could not collect the medical report of the injured.
No, my lord.
Is the
31,
medical
page
officer was transferred?
No, my lord, page 31, page 31.
Page 28.
No, my lord, that was subsequent certificate IO. 31 is the IO. 31.
But who is this 28?
28, my lord,
Gokul.
later on, my
talks
lord,
of medical-
entrusted to
I
him.
found that the investigation has been complete except collecting medical report.
My lord, that-
But I could not collect medical report injured as the concern was transferred. Huh? Correct, but he could not collect the medical report.
My lord,
And then, so he says, because I could not medical report injured, as the concerned medical was transferred.
my lord, in this case, my lord, the whole, my lord, if there was the deposition, they have stated everything from everything detail.
Earlier IO,
PW9,
PW9, PW31.
page 31.
At page 32, that sentence is there. It is not the fact that I did not collect any medical reports of these.
Space.
Page 32, first paragraph, last two lines.
Last two lines.
It is not fact. I did not see any weapons in connection. I did not see the blood stain wearing clothes injured Sheikh. I did not see any blood wearing clothes of injured Sheikh Farid and Rohima. Who is this Sheikh Farid?
These are the persons.
Huh?
Rohima is the person that has.
No, Sheikh Farid. Yes, he's the one.
No, Rohima is the one.
See, Sheikh Farid also said, the accused Amir Hussain hit me on my head. I became senseless and fell down there. After 10 minutes, now he said, I did not see any blood stain wearing clothes of injured Sheikh Farid and Rohima Khatun. It is not a fact that I did not collect any medical reports of these two injured persons. Therefore, the trial court gave a benefit in absence of this medical evidence. Perhaps we cannot acquit you, convict you for causing grievous injury. It's okay, fine. But it does not mean, does not say that they were not injured. They said two injured persons again and again.
My lord, with regard to the authenticity of the PW3 on which my lord is relying, my lord, I take your lordship to on the deposition, my lord, of at page number 12 of PW2.
Yes,
Yes, my lord, this, I take your lordship mm, my lord made take PW1 also and PW2 also.
Hmm.
PW1,
yes,
PW1 at page
Yes.
page 10,
yes,
the cross part.
yes,
On the day of the incident, it was raining heavily from the night till the morning. On hearing commotion, I came out of my house. It was around 8 a.m. when I came out. Till then, I did not hear any hue and cry raised by Rohila, the wife of the deceased Amir Ali and his son Sheikh Karim. My lord, what? Then, my lord, I take you. This is with regard to my lord person. Then PW2.
I
PW.
don't know who killed the deceased. I saw injured Amir Ali.
Amir Ali sitting on the land of accused.
Who is Amir Ali?
The deceased.
This is sitting on the land of accused Amir Hussain, some away from the dead body of Malik. Malik. Oh, the two persons
Two
died.
persons, my lord, two persons.
I did not see any blood stain at the place of occurrence. I did not hear about quarrel between both the parties. Then,
Then I take your lordship to PW2.
yes,
PW2.
yes,
My lord, I will read in total PW2.
don't read total. You want to tell
Give
us
me-
what is
My
it.
lord,
Otherwise,
then
you can argue the
you
case
will
also.
go to the,
Huh?
my lord, I then I.
But we will not allow to hear you on the bail.
My lord, then I.
Tell us the relevant
Read
portion only.
relevant portion, my lord. My
Page
lord, page
number?
12.
Page 12, yes,
Because my lord, I'm bringing this to prove the authenticity. Page 12 at the 5th line.
yes,
Thereafter, thereafter I proceeded and saw that my stepmother Rohima Khatun, not accused Rohima Khatun, was coming to our house holding her bleeding hand. My lord, please. On being asked by me, my stepmother told me that the accused person had killed my father and younger brother. Then he stated, my another brother, Sheikh Farid, was also lying there in an injured state. My lord, may come to his cross at page 13.
yes,
Page 13, first, second, third, fourth paragraph. Here, I found injured Sheikh Farid on the road in front. I came across my stepmother near the
page
house.
14,
Page 13, my lord.
page 14.
He stated that he has seen his mother, he has seen his stepmother.
Yes.
Let us come to the version of stepmother. What's he stated? PW4. PW4. She stated that, my lord, the first paragraph, last third line.
Page.
Page 21, last page 21, first paragraph, last third line.
Yes,
But Ruhul Amil also hacked me on my head with a dowel. Then I became senseless. Later I regained my senses at
who is this? Page.
PW4 is the person my lord was asking.
Rohima Khatun.
Yes, Rohima Khatun. According to her version, my lord, she became senseless there and then.
Yes,
According to version of PW2, who is an eyewitness, he stated that he saw her holding his head coming towards him. In due course, there was no seizure with regard to any bloodstained cloth, no any injury report with that regard. So, my lord, whether this PW3 can be taken into consideration, the version PW4, my lord was asking about Rohima Khatun. Rohima Khatun, she stated in her deposition that she immediately became senseless there. The eyewitness stated that she was.
no, we are not so much concerned with Rohima Khatun,
My lord was
because
asking-
she's already on bail.
No,
Huh?
there are two accused is also Rohima Khatun. Both are Rohima Khatun. My lord was asking about Rohima Khatun only.
Rohima Khatun, that is
Which
an
one?
accused.
Both
You
are
are-
Rohima, two Rohimas are there in this case. One has gone on bail accused and the other is the eyewitness. My lord was asking whether Amir Ali has assaulted this, given head blow to this Rohima Khatun. My lord was looking on that aspect. Both Rohima Khatun, same name.
In fact, as far as other 4 accused are concerned, there are enough material. In PW3 statement, 4 statement.
That is
But
what,
Idris Ali, of course, I've tried to find out. I could not
see,
see.
there is a concern. Meanwhile, my son Sheikh Farid arrived there and accused Rahul, hit him on his leg with a lathi.
Lathi,
Page 21.
yes, my lord.
He's,
Lathi and one in his.
so this
My lord, my
Sheikh
son-
Farid arrived and accused, hit him on the neck with, therefore,
No, my lord, my only submission is that My lord, said to my senior, 149 for me, my lord, the to attract 149 is not there with regard to
That
Idris, my
will-
lord. If 149 goes, my lord, with regard to Amir Hassan, what will be the figure? So, my lord, considering his medical conditions. and
Oh,
timing-
don't bring in medical condition. It's not nothing to do with merit.
My
He
lord,
became
my
became
lord,
sick
if
later on.
merit- if 149
Don't
goes-
bring your medical condition purely on merit.
my
Huh?
lord, if 149 go, then he's.
That
my
we'll
lord,
see in the at the time of hearing final argument. You want us to decide 149 at this stage?
My lord, my lord, only this 149 came only of this statement. That's why I made submission last year. On 149 came only of this statement. Because 5 persons, this constitute.
So all they are all related. All is a group. Father,
No.
mother, two sons. They are vehemently protecting their property right. Is that how dare you come and plow? So they hit him. They hit.
149,
So that was jhagda. Jhagda to hua.
149 for 149 for 5 persons, my lord. The unit group 149.
Oh, calculate. Oh, 5%.
So if
That
person-
made.
there is a juvenile. Even if we take out Idris, but a juvenile is there, so the
No,
total
but
comes
right
to-
now all you are five appellants accused.
Even if we take out Idris from common object,
Just because we have given granted bail to Rohima Khatun doesn't mean that 5% is no more, cannot be counted.
no, 5 persons are there.
Five
If your
persons are
lordship
there.
excludes Idris Ali, he being not the relative of anyone, if he is simply a worker,
No,
then he
no.
might not have entered into any common object. But then there was a juvenile whose case was sent to the juvenile board. So the total comes to 5. So 149 is well.
So you are emphasizing the number five numbers huh, for 149.
That's a mandatory 5.
That will see that. No, correct. But then still Muhammad Idris Ali also there. He also, you can't discount him. He was present.
At this stage.
At this stage, he was present. You can't discount him. We are not acquitting him, but we are giving a benefit of doubt at this stage for the purpose of bail. Because his name does not appear to be reflected in any of the witnesses except saying that he was plowing the field. And since Idris Ali has not been shown to be related to any of the other accused
checked all
who are
the
otherwise
statements.
accused, where they belong to the same family, father Amir, mother is Rohima, two sons Rahul and Amin. So it is very natural that they would be together to defend their proprietary right. That one can understand. But Idris Ali is a worker.
The
Why?
informant is also there. He also will know.
Who is the informant?
He is appearing for the informant.
Don't, yes, Mr. Informant, anything you want to say on this discussion which is going on? What? Of Jahan, very good.
What I wanted to know from him whether Idris Ali was a relative, because in none of these statements it is shown. Who was he?
Hmm? Idris Ali is related to them. There is nothing on record.
To be fair,
Only
I peruse
presence,
that point
only
everywhere.
presence would be very risky because Supreme Court has said spectators, onlookers should not be involved in 149.
No, he is not an onlooker.
Mhm.
I mean, he's very much in the field. He knows. He's also, maybe we don't know whether he was plowing illegally or not. He maybe
Yes.
said, "Arey, this is my property." He must have Idris.
No,
if
his
they must-
presence is undisputed.
His presence is not disputed.
He was plowing the land of the one of the petitions.
Obviously,
One
because
of the
he's
petitioners.
unless either he's plowing as an owner or an employee.
Of Amir Hassan.
Either he cannot be an owner because he's not related. You have not shown that he's related. Therefore, most probably he's a employee or he has been engaged. If not employee, engaged to plow.
Mm.
So if it's mere engagement, we should not read too much.
Mm.
If he have been relative, if he's another third son, then we can say that yes, they knew what the act they're doing.
And it seems he was the only person who was plowing and all of them were sitting beside.
Sitting.
So perhaps he was a worker whom they have engaged. Can be, but subject to correction later during the hearing.
So what do you want? Yes, tell.
Only Idris Ali I'll not object, but otherwise Amir Hassan and
My
all.
lord,
they-
I'm praying for Idris Ali and along with it, I leave with your lordship, I'm praying for Amir Hassan. So at this stage. And
Amir Hassan will ask the government to take more care
Yes, that I can ensure and I can tell.
because Amir Hassan is a father figure, no? He's not only the father but father figure. he must have asked Idris Ali, go and plow, don't worry, I will take care.
Yes.
If anybody help him, we'll take care, don't worry. I have two sons,
Yes.
don't worry. So that Idris Ali must have plowed.
And
with that
one
con-
submission, last submission with regard to Amir Hassan. My lord, this report is contradictory, but 180/80 is stable. How can that be? I don't know.
I don't know, see, sometimes we don't know, they are doctors, no, we are not doctors. We are not doctors, we can't say.
And only submission, my lord, I'm praying for Idris at this stage. Can you detail with regard to Amir? Because my lord, my only submission, his son has informed one of the son that is out, he's not well. Every time he may not, my lord, survive also. According to their version, my lord, I'm not sure. My lord may call for a detail with regard to Amir Hassan because 180/80 and they are saying it's stable. After that, I don't.
Okay, we can give a suggestion. If you are not happy with this, not Lakhimpur, any other place where you can, no, Lakhimpur, which is the nearest good hospital, no, Lakhimpur is a good hospital.
They are jail authorities, I don't. my
You
lord.
know, na? Dibrugarh, how far Lakhimpur and Dibrugarh?
No, my lord, jail authorities, they are taking care. They are taking him to hospital every time. I'm not giving with regard to the role of the jail authority. They are taking care of him. But his health, and only on his health. Jail authorities, I asked that whether he's taken to hospital or not. They are stating that he is taken to hospital every time. The son is informed he comes every time he's taken to hospital, but he's been treated by a doctor. He's with regard to his hypertension and with time he has left food and everything.
And he has been detained when? He has been in jail since?
Husband.
2019.
19.
Oh, 2019 only.
19.
Judgment of 2019.
Yes.
Uh, This superintendent jail Lakhimpur, but then why can't we get him treated, treated in Lakhimpur Medical College?
Not yet, yes.
And we'll get a report. They're saying that their father may go anytime. That is that's what instruction. Now this is a report of the jail.
Officer, district jail.
Jail.
Jail hospital.
So let him be taken to Lakhimpur, this medical college
He was
with
taken
experts.
He was taken there only, but when submitting reports, this person used to visit along with that. So report is
No, he was
Yes,
he
he was
taken?
taken
Okay, he
to
was referred to Lakhimpur Medical College.
report to it is reflected.
So it's just there.
My lord, I'm admitting, my lord, that part I'm admitting.
Then if he's
treated.
taken care of, then
He's
why
taken
should we
back.
release on that ground? No, then otherwise, see, everybody will come. I'm suffering so and so jail. Like, if it is the case that the jail authorities are able to provide the treatment,
That I'm not.
then
No, that is not true because they are providing, because every time he is taken, he is called, it means like in a month, he is taken twice, 4 times. He is taken. And the main issue is his pressure problem, my lord, and along with it, he has left food.
but then see, madam, at least the jail authorities are taking
But
3-4 times a
that-
day.
that-
You may not be able to take him then.
My lord, that I admit, I'm admitting fairly, he is taken care. On last, so I submitted.
And what is your see financial position? Why are you are in other accused?
All the persons are named here, all were inside jail, only the wife went out. And
Correct.
went juvenile,
Correct.
and all brother, whole family.
They are all
is
from Lakhimpur.
all looking for all depending plowing land and all those.
See, then they won't be able to take him. If he release on bail, he may have problem.
His wife is out.
Wife,
and
this
then
old wife,
his
what she will do? She can't carry her.
One son is acquitted.
Second wife.
One son is acquitted.
There is juvenile.
Juvenile, he was acquitted. He's major. He's acquitted. My lord, I leave it to your lordship, my humble plea, my lord, with regard to
No,
Amir
that is
Hassan.
correct. Even the family members will not take.
She
care.
won't be able
The
to take
way-
care.
Lord, that is not the position, my lord, because, my lord, I leave
At
it
least
to
the
your
state is
lordship.
taking care.
My lord, I
Health-
leave it
health
to your lordship.
status.
My lord, with regard humble prayer to consider Amir Hassan and Idris Ali, my lord, my humble prayer. My lord, I leave it to your lordship.
He is undergoing treatment, recovering. You see, the word is recovering.
My lord, his condition is stable, BP 185.
Women, 180, 180.
We can ask a medical board to submit a report like, as far as this Amir is concerned.
My lord, my lord,
Idris perhaps, Idris perhaps,
my lord, I'm okay.
Nico. But we are not allowing others. How
My lord,
many?
my lord, my lord is calling.
To
for a
Rahul Amin and Nizamuddin, we are not allowing.
report. Please,
Nico, hard miss. Hard miss?
SG Borua.
What is SG Borua?
Sumita Gohai Borua.
Sumita.
Gohai Borua.
Sumita Gohai Borua.
Borua.
Borua. There's so many Sumitas also now.
Sumita, my lord. Sumita is one.
Sumita is one.
Yeah. M, not N.
M.
M for Meghalaya. Yeah. Sumita.
Sumita. And Miss Sumita
Gohai Borua.
Gohai Borua. Then a counsel for the applicants. Are also Miss Jahan. Then an additional PP. The present application has been filed for grant of bail in respect of 4 convicts who are presently lodged in jail, namely, number 1, Amir Hassan, alias Amir Hassim, is about 68 years. Number 2, MD Idris Ali, is about 56 years, son of late Qasim Ali. Next, number 3, MD Rahul Amin, is about 36 years, son of Amir Hassan. Number 4, MD Nazimuddin, is about 20 years, son of Amir Hassan. As regards MD applicant number 1, MD Amir Hassan, it has been submitted by Ms. Sumita that he is an old and ailing, suffering from serious ailments, because of which he has been constantly, because of which he has been constantly being treated in the Lakhimpur Medical College. In fact, as can be seen from the medical report which have been submitted today by Ms. Jahan, which indicates that he had been suffering from general weakness and he's a patient of hypertension with BP measuring 180/80. With pulse 82 is okay. Pulse 82 is okay. Huh?
Anything,
82,
uh,
82.
80 to 100 is, I think. okay.
Pulse 82 is not very normal. Huh? Only the BP. Huh? Though
No.
it has been submitted that though the concerned doctor of the district hospital had certified that at the time of examination his vitals are stable. Considering the high BP mentioned in the report, Ms. Sumita has expressed serious concern about his present health. And accordingly, it has been submitted that, in fact, she has been also informed that said Amir Hassan is suffering from other ailments, and as such, he may, and as such, if he is not properly treated, he may, it may be fatal. It may prove fatal. These may prove fatal to him. That apart, it has been submitted that on merit, the role played by the said Amir Hussain is not clearly spelled out. There are contradictory statements made by the prosecution witnesses. It has been submitted that while PW that while he was hit on the head, that who said?
PW3, page 73.
While PW3, Sheikh Farid stated that the appellant hit him on his head. And also, he hit his father, deceased father, on his head with a lathi, comma. Other prosecution witness, namely Musammad Rahima Khatun, PW4, stated in her evidence that the appellant Amir Hassan hit her husband, deceased husband, on his legs. So therefore, therefore it cannot be said that because of the aforesaid inconsistent stand plea taken by the witnesses, the actual role played by the said applicant number 1 cannot be said to have been fully established. Next para. As regards the second applicant, it has been the second applicant MD Idris Ali, it has been submitted that apart from the evidence from the mouth of PW2 Abdul Quddus that he saw the appellant Idris Ali plowing the land belonging to the other accused Amir Hassan, there is no reference to any role played by him in the incident. It has been also submitted, it has not been also shown that the said applicant number 2 Idris Ali is a member of the family of Amir Hassan, Rahul Amin, Nizamuddin. And as such, in all probability, he was engaged by the accused for plowing. And as such, and accordingly, he cannot be imputed with any common intention which can be attributed to the other family members who apparently were protesting the plowing of land by the victim's family.
Common object.
Huh?
Common
A
object.
common object. Huh? Under the circumstances, it has been submitted that full stop. If further, it has been submitted that to form to constitute offence under section 149 IPC, the role of minimum 5 persons, at minimum 5 persons must be involved with a common object to commit the crime offence. However, the said not being fulfilled, section 149 cannot be invoked, and this on this ground also the said Idris Ali is liable to be maybe granted bail. As regards other applicants, Muhammad Rahul Amin and Muhammad Nazimuddin, what is your plea? The Ms. has also taken the same plea, saying that if section 149 IPC is not applicable, they will be also entitled to release bail at this stage. We have heard on the other hand, Ms. Jahan, APP, submits that though the role of the second applicant, MD Idris Ali, has not come out very clear except for the fact of having seen plowing the field allegedly belonging to the victim's family. As far as the other applicants are concerned, their role are clearly discernible in the evidence, with certain specific role played by each of them. it has been further submitted that there were more than 5 persons involved in the incident. Not only the present 4 applicants, but also the mother of the, but also Musammad, what is that? Musammad, also Musammad Rohima Khatun, wife of Amir Hassan, who is now released on bail, and another
Juvenile.
juvenile, huh?
Noor Muhammad.
Noor Muhammad, a juvenile who was proceeded before the concerned juvenile justice board. Therefore, the fact remains that there were as many as 6 persons involved in incident, and as such, the question of improper invocation of section 149 of IPC does not arise. In fact, it is very much applicable in the present case. We have heard learned counsel for the parties and considered the materials on record for the purpose of consideration of bail of the 4 applicants. While we have also noted that Amir Hassan appears to be suffering from certain ailments, we also have noted that he has been given medical treatment by the jail authorities. However, considering the concern expressed by the applicant, by the counsel for the applicant, that his condition is precarious and if not given proper treatment, it may prove fatal, particularly referring to the high BP of the said applicant number 1, which has been recorded as 180/80. In this regard, we also of the view that the condition of any inmate must be properly taken care of, and if necessary, if necessary, grant of bail on medical ground can be also considered. However, before we make any consideration, we will require that the said applicant number 1 be examined by a board of doctors.
Medical board.
The medical board of the Lakhimpur Medical College, and submit a report before this court as about his health condition, so that the issue of consideration of bail on medical ground can be considered appropriately on the basis of such medical report, which may be furnished by the Lakhimpur Medical Board of the Lakhimpur Medical College. As regards merit, we also have noted that though the evidence of PW 3 and 4 appear to be varying as regards the place of assault on the as regards the manner of assault by the applicant number 1. Yet it is also yet it cannot be said that he did not play any role in the said incident, and as such, at this stage, we are not inclined to grant bail on merit. But whether we should consider his grant of bail on medical grounds will be considered after obtaining the medical report from the board of medical board as observed above. Full stop. Next paragraph.
The superintendent of Lakhimpur Medical College can constitute the board.
Okay. For the aforesaid purpose, the superintendent of the
Lakhimpur Medical College.
of the Lakhimpur Medical College can constitute the medical board to examine the medical condition of Amir Hassan, applicant number 1, Amir Hassan, alias Amir Hassan, alias Hassan, alias Amir Hassan, is about 67 years, son of late Umaid Ali. Coming to the, as regards Idris Ali, applicant number 2, we also have noted that apart from the allegation that he was present in the place of occurrence plowing the field, there is no other evidence coming forth to show his involvement in the incident. All the acts which cause injury to the deceased and the injured person appear to have emanated from other accused persons, namely accused persons, not from MD Idris Ali, the applicant number 2. It has also brought to our notice that it has not been established conclusively that he is related to the other accused who are otherwise members of the same family. Therefore, the contention that he is not he is merely an employee or engaged to plow the field which belong to the victim's side does not appear to be unreasonable or unbelievable. Under the circumstances, as the role of the said Idris Ali has not been clearly pointed out for the purpose of grant of bail, we are satisfied that he has been able to make out a case. Accordingly, we allowed the application for release of MD, the second applicant, MD Idris Ali. MD Idris Ali, son of, is about 56 years, son of late Qasem Ali, to be released on bail. That the condition district judge will, or, you don't require to, subject to, on such terms and conditions to the satisfaction of the learned session judge, Lakhimpur.
Yes.
With the
It
judge
was
there.
passed by additional session judge FTC Lakhimpur.
Okay, which is judge, additional, huh?
Additional session judge FTC Lakhimpur, not.
Additional session judge within bracket FTC Lakhimpur, not Lakhimpur. During the
Juvenile's name was mentioned.
Hmm.
We'll have to do another name.
Okay, sorry. Don't mention the name of the juvenile,
Yes.
then
Even. I
because
stand
that is
corrected.
not
But yeah, it should be.
no, that
omitted.
he should not be mentioned in the order.
In fact, this was the second bail application.
Of
Yes.
whom?
All the persons.
Okay. As
Just
regards the
apart-
other remaining two applicants, we are not satisfied that they have been able to make out a ground for enlarging them on bail, considering the evidence which are on record. Accordingly, we decline to grant the bail in respect of the remaining two applicants, MD Ruhul Amin, son of Amir Hassan, and MD Nizamuddin, son of Amir Hassan. Okay,
The main
let the
appeal-
matter be listed after.
Main appeal paper book is ready.
No,
everything
my
is
lord,
No, about this.
Medical look, my lord.
Oh, yes.
After the vacation, immediate.
Full stop.
They should be given some time, I mean. A
We
prescribed
we
time period.
accordingly close this IA. However, the applicant number 1 is permitted to file a fresh application, along with any other additional documents which he may seek to rely. Additional medical documents which the petition applicant number 1 may seek to rely on. You file a fresh application.
My lord, with regard to the report,
Report that, the report will be submitted before this court after
Maybe within 20 days after expiry of 1 month.
1 month, 1 month.
my lord, may I be the date may be fixed because I will not be aware of. the
Acha,
report.
okay, and copy of which may be furnished
Yes,
to Ms. Sumita.
or the accused persons, they can provide to them. They
Sorry,
can provide a copy. That will do, my lord.
they will provide to you.
Yes. They can provide to me
Let
or.
her
Because we are closing this application,
Yes,
we don't
my
want to keep
My lord,
mixing
my
up.
lord. That would do, that would do.
The report will
Uh,
be sent to the ministry.
The applicant may file a fresh application along with a copy of this order passed today.
My, lord.
Then we'll know what is
Yes,
the,
my lord.
we'll know the connection.
My. Obliged, my lord. Also,
Oh, hard also Ismail, please, Naam, for the informant, no?
obliged, my lord.
You are for whom?
She's with it.
Huh?
With,
Item number 16.
Yes, is it confirmed?
Lordship, I forwarded the copy, but the petitioner says that there are some mistakes in the calculation part, Lordship. So the petitioner prays for some time so that he can confirm with the account section of this
Okay.
High Court, Lordship.
Okay, okay. Add Ms. D. Psychic. And counsel for the, also Mr. And counsel for the CGC. Huh?
For 1 and 2.
Oh. 1 and 2. You're okay?
For respondent number 3.
You're good? Your
Miss D. Mohanto for respondent number 4.
Okay. Sab ध्यान रखना. It has been submitted by Ms. D. Saikia that though the area appears to have been released, the amount does not appear to be correct, for which the petitioner seeks some more time to ascertain the correct amount to be released. In that view of the matter, let the matter be listed after puja vacation.
Lordship. Lordship, can the date be fixed, Lordship?
Date after puja vacation. When do you want? Tell us.
Lordship, 31st,
31st of
that is Monday, I think, Lordship.
31st of October.
Lordship.
31st of October.
Deeply obliged, Lordship.
Daily list for hearing, item 13.
What is this hearing? What is this hearing matter? That NIA matter. File.
I was waiting for the whole morning, but I think I've I told by my friend
Which one? Which one?
that item number 4, part 2, Subur Mandal.
Oh,
So I think this matter will also take up your lordship's whole day. Well, today I take your lordship. Tomorrow again I will try my luck.
oh, Subur Mandal, no?
Yes.
Okay.
First time I did not have my luck today, so I'll try it tomorrow, not in the second.
So luck also plays a big role in our judicial proceedings,
Yes,
it
yes,
appears.
yes, yes,
Huh?
yes.
Luck also.
Yes. Well, that's why it's now the trend is to say when there are 24 judges in the High Court, it's not one High Court, there are 24 different.
Okay.
34 judges in the Supreme Court means not one Supreme Court. There are 34 different Supreme Court because
Okay.
man has different views.
And what is the first thing you would like to know about the judge?
First thing is that when we are junior, we are told that if first, instead of knowing the law, you know the judge and never fight with the judge. If you fight with the judge, half the case is gone there.
All the juniors of Kaur are all giving a approval, smile of approval.
Lordship, he is letting out the trade secrets. He is letting out the trade secrets.
And my seniors and all also told me when I first joined the chamber that never have an affair with a lady advocate. But my misfortune is that I got married to a lady advocate only. So, and she knows the law. So we have to be very restrained in what we speak at our home. And if someone files a 498 case against me, they will say that yes, Bhaskar was like this, he deserved this. All the sympathy will be with the lady. They will be the angel, goddesses of your lordships. I take your lordship to the leave.
Okay.
I'll start tomorrow. Deeply blessed.
Worship, here the appellants have made their arguments. In fact, I was also nearly completed. I have taken your lordship to the. Yeah.
Yes, yes, please proceed.
Lordship, I have taken your lordship to the provisions of section 43 and the proviso to subsection 5 of section 43 B. It states that provided that such accused person shall not be released on bail or on his own bond if the court on a perusal of the case diary or the report made under section 173 of the court is of the opinion.
Saidul Islam, no? Saidul Alam,
Yes,
Saidul Alam. Just can you just again just whatever we have stated
yes,
earlier?
very briefly, I'll try to support. Lordship.
Mm.
I had referred to section 1, section 43D proviso, section 43D5 proviso, where it states that provided that such accused person shall not be released on bail or on his own bond if the court on a perusal of the case diary, lordship will note, perusal of the case diary or the report made under section 173 of the court is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Here, as it reveals from this proviso, lordship will look into the CT and the report under 173. Here, lordship, I would say the trial is in progress. Therefore, the depositions made before the trial court would not have a bearing when the bail is taken up under the proviso of the section. And the charges are lordship under section 18, 38 of the Unlawful Activities Act, read with 120B, the IPC. In this connection, lordship, submission was made referring to section 15 of the act, that no such act, terrorist act, has been committed. For that matter, I refer to section 18 and section 15 of the UAPA Act and made a submission
But section 18 does not need an act actually to be committed. Because it starts as whoever conspires or attempts or advocates, abets, advises, or incites, directs or knowingly facilitates the commission of a terrorist act or any act preparatory to the commission of a terrorist act shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and shall also be liable to fine. Here, unlike section 15, which is attracted on commission of the office, this is something which is in preparation of doing an office. It says who conspires or attempts or any act preparatory to the commission. Therefore, it is not necessary that he has actually committed the offense. Whereas section 15 says whoever does any act, the action is already committed with intent to threaten or likely to threaten the unity, integrity, security, economic security, or sovereignty of India with intent to strike terror or likely to strike terror in the people or any section of the people in India or any foreign country. Since there was a submission that no act has been committed, therefore, I had taken your lordship to the provisions of section 15 and section 18 to differentiate both the sections. Here he is not charged under section 15. Here he is charged under section 18 and section 38. Section 38 is offense relating to membership of a terrorist organization. A person who associates himself or professes to be associated with a terrorist organization with an intention to further its activities commits an offense relating to the membership of a terrorist organization.
This charge, page number,
Lordship, I have given a bunch
that,
of papers.
whereas
Lordship.
you're also in the application also there, no?
It is there.
Huh?
Yes.
The charge section, what are the sections,
147,
please?
147. And main portion is at 151.
Number 120. B.
Yeah.
IPC. Number 2 is section 18.
Yes, ma'am.
Huh? 18. Number 3, also UAPA, 3, 18B. 4, 38. Yes,
Now, Lordship, with reference to section
charge of Kamru Zaman, but this is Kamru Zaman.
Zaman is A1.
No, we are dealing with
sorry,
Saidul
Lordship.
Alam,
Yes,
no?
yes, yes.
So then
Lordship,
Saidul Alam.
155.
Please?
155.
155, okay. Saidul Alam,
Yes.
yes. So also 120B,
Year one.
18,
is not there.
18B is not there.
Yes, no.
Only 3 charges, huh?
Yes, Lordship.
38, yes.
Now we have to see in terms of section 43,
Section?
section 43.
No, you have said that
5B.
as far as these 3 charges are
No.
concerned, your case is that Section 18 of the UAPA Act does not require actual involvement or actual act being executed.
There has to be some
Suffice,
preparation.
suffice preparation, suffice you are involved in the conspiracy. You may not be directly involved in the act. So in that throwing of bomb, you may be direct, but you may be watching, having undertaken your part on the preparation. So there is your case. And what about 38?
38 is offense relating to membership of a terrorist organization.
Hmm.
Now,
So how is he a member of the terrorist organization?
that I'll come now. He is, so far as now, Lordship, it is alleged with me. If your Lordship will take the first schedule, Hizbul Mujahideen. Lordship, in my book, it's page 30,
First schedule.
first schedule, serial number 8.
Hizbul Mujahideen.
Yes.
Acha, Nargis, you are only for this,
I do.
Saidul only, na?
Yes.
Or others also no?
Other, in trial court, I'm
Huh?
representing. Trial court, I'm representing other person.
But in this, before this,
Saidul.
only Saidul. Yes.
Now, Lordship, in terms of section
Yes.
43D,
Yes.
I am to satisfy your Lordship whether there is a prima facie case. Whether
Yes.
whether he is a member of Hizbul Mujahideen.
Yes.
For that, Lordship, I had taken your Lordship to the statements made. I have given your Lordship a booklet, Lordship. And I have taken your Lordship to the statements made by Saidul Alam. Kamrul Zaman himself, Lordship, is the accused number 1.
Your booklet,
Yes, Lordship.
in that page number,
That your Lordship will find. Saidul Alam, your Lordship will find at page 73.
statement of Saidul Alam.
Yes, Lordship. That is the accused 3.
It is recorded of the 161.
It is 161. Of course, I have to refer to the 161
It is
statements.
by
only, Lordship,
162.
because
On last occasion, that was.
I have placed it. Because I can go only to the report submitted under 173.
Yes,
And the
Nargis, you are
statements made
saying
till
something
that-
what? What you are
that
saying?
extent.
It is recorded under 161
Yes.
and it is hit by 162. Lordship.
Hit by?
162, which was statement of accused while in custody under 161.
Correct.
That cannot be relied, that there are no
That has no evidentiary value.
That is for a matter of trial to see.
No, that is, it doesn't have, we are not in trial, we just only for bail,
In bail also, this
Huh?
is their document. This is their document.
correct?
So
But
that
then, but
the
then it is based on this that the charge sheet is framed, charge is framed.
160
On what basis charge is framed?
on the basis of the statement of the witnesses.
Huh?
Witnesses. This is accused statement.
I
Oh,
don't
the
know.
This is
accused statement.
Yeah.
Oh, I see. Oh, I see.
Yes, also.
Oh,
Now accused himself says,
The accused himself says in 161.
yes, Lordship. I'll come to the statement of witness also. I have read that out on the earlier occasion, Lordship.
Use 161 statement, we thought is a witness, accused, can you accuse? Can you use the accused statement?
Lordship,
If you use the accused statement, then there will be a lot of problem.
no, Lordship, let me place it this. The statements made by the accused person is also corroborated by statement made by a.
No, no,
witness.
we
I'll
are,
come to the witness statement also.
we cannot corroborate the statement,
I-
except which leads to discovery of fact.
Let me take. your Lordship to the
Except for
statement of the
discovery of
witness.
fact, because when charge is framed,
Lordship,
it is on the basis of witness evidence.
Lordship.
Whether it is proved ultimately or not, that's another issue to be
Yes.
seen. But can you look into the statement of the accused? Because that is not permissible, because there is a incriminating evidence, or self-incrimination.
Lordship.
Unless you say it's a confessional statement, then if it is a confessional statement, if you can say, yes, he made a confession before the magistrate, well, we'll consider whether it was voluntary or not, that we'll see later on.
Lordship. Let me take your Lordship.
So
to
then,
the-
so we can't look into this 161 statement of the accused.
Let me take your Lordship to the statement of. At page. 81, this in the. I have taken your Lordship to the statement made.
That statement could have been used by the police during the investigation.
Lordship,
During the investigation, it could have been used.
Lordship.
That you, okay, yes, the police does that, he made this, I mean, he did that, and but then that investigation stage is over.
That is what. Lordship. I refer to a statement made by one of Afazul Haq
Page
at page 11.
page 11 of your
Yes.
paper book. No, page 11, some Hindi hai ye to.
Yes, yes. yes.
Azaful Haq Atia.
Yes, yes.
Okay. This is also 161 statement or 164?
This is a 164 statement.
164.
There 161 not recorded.
Oh, anyway,
Without that 160.
and that we'll see, but we'll see.
Now,
Statement recorded under section 164 of whom?
of Afazul
Muhammad
Haq.
Azaful Haq.
Here it is Afazul.
Afazul
Fazil.
Afazul Haq. Atia.
Afazul Haq.
We have
Atia.
annexed the translated copy of this with our petition.
Okay, we'll continue.
Lordship.
We'll continue after.
sorry, page 11. It's in Hindi.
Translated copy is there along with
I'm just referring to that.
the petition. Translated copy is there along with the petition.
The same lordship of translation, lordship, your lordship will find this particular magistrate was examined in the court. And in his statement, it is extracted in English. That your lordship will find, it starts at page 81. And the.
Page
relevant-
81.
Lordship. 164 statement was made before this Sumit Anand. He was examined and the relevant part, which was given in Hindi, is translated in English in page 83. Just for the convenience of language, lordship, here, the English.
Yes, yes.
If your lordship will see page 83,
Yes.
he stated before me that I know Kamruz, Shahnawaz and Umar Farooq from childhood. One day the mother of Kamruz told me that I should take him to the place where I do business. Then I told her that we were looking after children there and do not have sufficient income. But his mother did not agree and told me to take him there and also told me that he will do something there if he wishes or otherwise come back. Then in 2013, myself, my family and Kamru went to Kishtwar,
Yes, yes.
which is in Jammu and Kashmir. After going there, Kamru started doing his work. This Kamru's lordship is A1. He started selling caps by spreading them on the bench. I also was doing my work. During that time, Kamru had interaction with one Osama bin Javed. This happened in 2015, and there was considerable friendship between the two. Then one day I heard with my own ears about discussion of jihad between Kamruz and the said Osama, and that they were saying that atrocities are being committed upon Muslims and that they will take up arms and join Hizbul Mujahideen. Thereafter, upon going away of Osama, I explained a lot to Kamruz saying that these things are wrong and that he should not listen to Osama. Then in 2017, during the winter, myself, my family, and Kamruz came back to our home. We came back to Assam towards the end of January 2017. Kamruz had called for a meeting in Milanpur Mosque. In the meeting, I was present along with Kamruz, Shahnawaz, Saidul is the appellant here, and Omar Farooq. There, Kamruz stated that atrocities are being committed upon Muslims, that innocents are being killed, and that they should do jihad, take up arms, and join Hizbul Mujahideen. Then he made everyone take pledge in the name of Hizbul Mujahideen, and that they will join Hizbul Mujahideen. Thereafter, Kamruz said that some dhamaka would be made in Lambing and Hojai. Lordship will kindly mark these words. Thereafter, I went to my in-laws' place at Gulaghat. After a few days, Kamruz telephoned me and told me that 3 guests were coming from Kashmir and that I was called to receive them. In the meeting that Kamruz had organized at Milanpur Mosque, he had also stated that the Kashmiri brothers will also support us. The 3 persons who were coming from Kashmir, I was to come to Guwahati to receive them. I refused the same to Kamruz as my daughter was unwell, but Kamruz did not listen to me and said that I will have to come. And accordingly, I came. I and Kamruz received at the Guwahati railway station the three guests from Kashmir, namely Faiz Malik, Abu Ala, and Osama bin Javed. Thereafter, we along with them went to the house of Kamruz at Jamuna Mukh. On the same day in the evening, Kamruz organized one meeting and said that atrocities were being committed upon Muslims and they will do jihad, take up arms and join Hizbul Mujahideen. In the meeting organized at Milanpur, Kamruz said that he is first Amir, second Amir is Shahnawaz, and Saidul is Alim. Saidul is the appellant herein. Kamruz also said that we will need money and arms for jihad, and therefore we'll go to the house of Bahar Bhai in Dimapur. On the third day, myself, Kamruz, Shahnawaz, and three guests went to the house of Bahar Bhai in Dimapur. There met Bahar Bhai and told him that money and arms are needed for jihad as atrocities are being committed upon Muslims. Therefore, jihad will be done along with Hizbul Mujahideen. But Bahar Bhai refused, saying that his wife was unwell and that he cannot help them. Then the guests told Kamruz that there may be short tea factory. Then Kamruz told me that let us go to the tea factory at my in-laws' place in Golaghat. On the next day, we went to Golaghat and I told my father-in-law that three guests came to see tea factory. Thereafter, my father-in-law took them to see tea factory. I and my father-in-law were waiting at the gate for the tea factory and other people went inside. They stayed inside for 30-40 minutes and then came out. That day myself and other people stayed in the house of my father-in-law. On the next day, all of us came back to Jamuna Mukh. It was the day of Jummah and Namaz al-Hadith style and therefore all had gone to the mosque to pray. There Kamruz and Osama bin Javed offered namaz in Ahl Hadith style. Then the people got annoyed and argument started. Then Kamruz said that he was his jihadi brother and they should leave the matter. Thereafter, all those people went to the house of Kamruz. On the second and third day, the guests went back to Kishtwar. Thereafter, Kamruz, Shahnawaz, and Umar Farooq used to talk about jihad near the lamp shop of Shahnawaz. About 2 months thereafter, Kamruz was going to Kishtwar, and then I told him to take his wife and children along with him, as I will also go along with my family. Over this, Kamruz quarreled with me, questioning my right to say so. Thereafter, he went alone. After a week, I came to Kishtwar along with my wife and children. Rashid can skip this middle portion. The last sentence of page. Then in 2018, Shahnawaz telephoned me saying that Saidul is coming to Kishtwar to join Hizbul Mujahideen. Whereupon I refused. Thereafter, I came to know that Saidul had come to JNK, but I did not know as to where he was. About 1-2 months later, the photo of Kamruz with gun in WhatsApp and Facebook started becoming viral. Then police showed me the photograph and asked me to identify. I told them it was Kamruz. After that, I came to know that Kamruz had become a terrorist. Thereafter, I do not know anything. At this stage, the entire statement made by the said witness was read over to him. After hearing and recorded the statement of the witness, further stated that after I lodged the missing report, I came to know from some local people of Kishtwar that Kamruz had joined Hizbul Mujahideen and become a terrorist of Hizbul Mujahideen. Then, when his photo became viral, I came to know this in a confirmed way that Kamruz had joined Hizbul Mujahideen and became a terrorist of Hizbul Mujahideen. Since Shahnawaz, Saidul and Farooq Umar were also in the meeting of Milanpur, I had suspicion that those three had also joined Hizbul Mujahideen and become terrorists of Hizbul Mujahideen along with Kamruz. I do not have anything to say. So, Lordship, prima facie, there appears to be a link between a Hizbul Mujahideen from his statement. They had joined Hizbul Mujahideen. Some planning was being done. Now, the statements which I was referring to prior to this, the statement of Saidul himself. Yes, Lordship, statement of 161. It may not be brought in evidence, but it does play a vital role before the trial court while framing the charges. Trial court has to go through it. It is a part of that. And the relevance, why I say so, this statement of the witness to some account is supported by the statement made by the accused himself. He also says, I go there. Now, if I may take if your lordship will see page 73 for a
Page?
page 73 for a the last paragraph portion. There also he says that there was a meeting at Milanpur market. There was a meeting in the Milanpur market, and at page 75, your lordship will remember the witness had said something regarding making blasts at Lamding area. At page 75, the first paragraph, the last sentence, second last sentence. During the meeting with Arzu, we decided and again discussed about executing blast in Lamding area.
Which one? Which one?
At page 75, lordship.
Again, discuss about Arju. Do you mean Arju?
Arju is not the accused, and neither he is accused nor witness.
But there is a discussion of making some blast, lordship. The preparation under section 18.
But before that, who is Arju?
We are not doing a trial, lordship. We are
Even
only
then,
trying
there
to
is no
find a
document to that.
prima facie case. If there are
Charge is
some
submitted,
materials to
but
indicate,
this person's name is not in the charge sheet also.
if there are some materials to indicate
Some
that
material on the
the
basis of
trial
what?
can proceed, that is enough.
On the basis of what? During meeting with Arju.
Now,
Hmm.
even lordship,
Okay. No, sir. Page number 75. Okay.
even lordship, at page 78, that is accused one.
It is also under 161.
Yes, that is relevant at the time of framing charge. That has to be looked into by the trial court. It may not be admissible in evidence. That is another aspect of the matter in the trial.
Can you show us the law that 161
Lordship,
statement of an accused can be considered for a purpose of
Lordship,
161 of other
yes,
witnesses? Okay.
Lordship, if we read 162, just I'll take it.
No, that we have, don't go to this book, CRPC, any judgment saying that 161 of an accused can be used for the framing of charge.
If I can definitely say something, but I'll give you.
No, correct.
Yes. But
While framing of charge, yes, 161 evidence of witnesses can be examined, correct, that is there. Because that's how the prosecution makes out the case.
161. The
Of other
prosecution
witnesses,
tries to establish some evidence, make out a case, but
Because why?
yes,
Why it is considered? Because the same witness is going to come and testify. So if he makes a different statement, he can be confronted.
yes.
Yes,
only
provided,
the-
But then
confrontation.
confronted, therefore 161 statement is
Yes.
all supplied to the
Yes,
accused.
yes.
But 161 of an accused, unless it is a confessional statement, it can, how can it be taken into account? Because he is not going to testify about himself.
Yes, Lordship, very true. Now,
Ah.
what?
Therefore,
I
if you,
was-
no,
why I
correct,
was trying-
if something which cannot be used, then how can we look into it? The question is that,
Suppose, Lordship, we leave apart the statement of the accused.
yes.
The statement of the witness is there. which-
Witnesses, yes.
which-
Azaful,
which
you mentioned Azaful.
which would testify that. Now let us see whether he had actually gone to Kashmir and all that. That your Lordship will see page 43. And page 44.
Please,
Page 43, Lordship. And page 44.
page 43 is what?
This is the season of the
Ticket. Traveling ticket
traveling ticket. Now,
from Delhi, Guwahati to Delhi.
Yes.
This will substantiate, Lordship, that this particular accused person had in fact gone to Kashmir at that relevant point of time. And I would also refer
Guwahati to NDLS.
to the call details, which your Lordship will find. I'll be referring to page 64.
Please,
Page 64.
yes.
And page 65. The prosecution story is, Lordship, he had been in touch with the accused number 2 all along while he was proceeding to Kashmir. And the dates, your lordship will notice, March
He was in touch with accused number 2.
2.
What is the name?
That is
Sanawaz Alam. But it is not in his name. There is no CA code.
Yes.
And thereafter, once he reached Kashmir, he switched off his phone, came back, he destroyed his phone. And now whatever was seized, the phone was seized from him. And lordship will see at page 51.
Page?
Page 51. Out of the so many phones, at serial number 11.
This mobile phone, yes, what is it?
Now,
What do you want to see that?
from the mobile phone lordship, what has come out is at pages 67 to these are the
No, what do you want to say on page 51 mobile phone?
yes, this mobile phone was seized from him.
Hmm.
And on sending it for retrieving the data, whatever was there,
Then what happened after sending data?
Yes.
Then what did you get?
at page 67.
Huh?
At page 67.
What did you get?
These are lordship photographs and videos of the Hizbul Mujahideen activities.
Oh. But this is not the photograph of the accused.
I'm not saying this is a photograph of the
That is why it's not relevant now.
So according to you, these photographs were found in the mobile phone of this
lordship.
Saidul when it was seized.
Lordship. Now,
Have you mentioned why is it? Have you mentioned this M2 or
Yes,
this
M11.
66 7 years? Why is it mentioned that these were recovered, retrieved from the mobile phone of?
lordship will come.
How do you
to
say?
Page that
This 67, 68,
lordship, I will come to page 53.
page 53.
Lordship.
Yes, page 53.
Page 53, Roman 3 lordship. Page 53.
Data from SIM cards have been extracted using forensic tools and digital data have been retrieved. For further details, for soft copy of the retrieved digital file provided was to Marcus PC may be referred to.
From there, lordship.
Huh?
Now, so far as lordship, the law is concerned, submission was made from the other side.
But why, how do you say, which is, this is that, why is it mentioned? That
Lordship, it has been provided.
page
on-
67, no, we are not questioning it.
Yes.
It may have been recorded, but how do you say this is the one? How do you say? 67? How do you say, just any reference anywhere that,
No, Lordship,
mark this
that was-
PDRC,
that-
NIA, Guwahati may be referred to. What is this PD?
A copy was, copy pen drive was given.
So copy pen drive, they cannot display right now because it was not materially exhibited before the trial court. And that copy also not provided to the accused person till today.
So that
How can they display this before this honorable court? This is not a trial court.
she was not the counsel at that point of time, the early.
No, that
earlier
was
that
not,
she said-
if it was there, then they can show that in the record. Whether it is provided, or right now, if it is not with me, but he cannot.
Mr. Dev,
Lordship,
have you supplied this to the accused? Not to, not to be, not to
Counsel.
counsel, can you just, because he,
I am a bit handicapped.
no, oh,
My senior is not there.
who?
Satyanarayan.
Satyanarayan is not there.
Satyanarayan, oh.
But Lordship,
But
the
I
fact
can
is that
of course, Lordship, get back on.
Correct.
But Lordship, on last occasion, on the last day, we have filed a petition to that trigger. Then he admitted that, yes, we have not provided this thing, so we are going to provide this right now. We are not on that, but thing is that, Lordship, if it is not materially exhibited before the trial court, how can they open these things before the appellate court?
All right, Lordship. She has filed an application, if she has not got. Okay. Let's see the log. They were referring to decision rendered by this honorable court in Rosenborough. And the submission was made that the NIA had preferred an appeal before the honorable Supreme Court. It is not correct, Lordship. Not against the judgment. There has been no appeal against the judgment of the full bench. I would just like to refer to a few paragraphs of the full court judgment. If your Lordship has Rosenborough.
Brozen?
Rosenborough, our full
That
full
was
bench judgment.
reported in Lordship
Brozenborough.
Rosenborough, 2016 for GLT, Lordship.
2016 4 GLT 803.
Exactly.
In Lordship, my journal, it is, I would be referring to paragraph 26. It starts with having noticed the operational fees.
Rosenborough was, yes, what do you want,
Yeah.
Rosenborough?
I have to refer it to paragraph 26.
Yes,
This scholarship in my journal, it starts with having noticed the operational things.
have you noticed the operational
Yes,
fields of
yes,
section
yes.
228?
Yes, yes. Yes. I'll refer to a few paragraphs. Having noticed the operational fields of section 228 on the one side and section 443D5 of the ULAP Act on the other hand, what emerges from the above is that while scrutinizing the materials on record, if there is a strong suspicion that the accused has committed the offense, or there is a strong suspicion about the culpability of the accused, that would be sufficient for the court to frame charge against the accused under section 228 CRPC. However, while considering bail of a person arrested on an accusation of having committed an offense, the chapters 4 and 6 of the ULAP Act, the court must not only form an opinion of the accused against the form an opinion that the accusation against the accused is prima facie true, but such opinion has to be based on reasonable grounds, which has been explained to mean something more than prima facie grounds, contemplating substantial probable causes for believing that the accused is guilty of the accusation. Thus, the standard of scrutiny in both the fields are different. While it is strong suspicion at the stage of framing charge, on the other hand, while considering bail application under section 435, it is something more than prima facie ground for believing that the accused is guilty of the alleged offense. In other words, the standard of scrutiny to determine prima facie correctness of the accusation against the accused while considering bail under 443D5 is much higher than at the stage of framing the charge. Then I would take your lordship to paragraph 30.
Yes,
We also have to keep in mind that while considering prayer for bail at a stage post framing of charge, no doubt section 43D5 of the ULMP Act is a special provision which has been introduced as a part of the state's response to the menace of terrorism, which is affecting large parts of our country, and that its conditions are extremely stringent. Here we have to bear in mind that by specifically mentioning the words on a perusal of the case diary or the report made under section 173 of the court in the proviso to the subsection to the section 43D5 of the ULFP Act, the legislature has prohibited consideration of any material beyond the case diary or the report made under section 173 CRPC for consideration of bail. The inevitable consequence being that any evidence led after framing of charge would remain outside the purview of consideration for
Yes.
Your Lordship, so far as bail, granting of bail is concerned, Lordship, the position of law is more or less settled. That the court can consider granting of bail even after the judgment of frame. But there has to be some circumspection, Lordship, and that is what the full bench said right after that sentence, where I have stopped, Lordship. It says, but having said, I'll just read from before. We have to bear in mind that by specifically mentioning the words on a perusal of the case diary or the report made under section 173 of the code, the proviso to section 43B5 of ULAP Act, the legislature has prohibited the consideration of any material beyond the case diary or the report made under section 173 CRPC for consideration of bail, the inevitable consequence being that any evidence led after framing of charge would remain outside the purview of consideration of the limited purpose of granting bail. But having said so, it cannot be overlooked that grant of bail is a discretionary power conferred upon the court. Though extremely stringent conditions are imposed while considering bail under section 43B5 of the ULAP Act, it is one thing to say that discretion is to be exercised by the court with circumspection, having regard to the stringent nature and the overall object of the provision. But it would be an altogether different proposition to say that the court would have no jurisdiction. I would only say that court has the jurisdiction, but some circumstances.
No, okay. What you are trying to convey by referring to this para 30? What do you want? What point you want to wish to?
Because an argument was sought to be made
Yes.
that some witnesses has deposed this way, some witnesses have deposed that way.
Okay.
Lordship, whatever is.
So
going on in the trial,
yes.
This honorable court will not.
So
be bothered
according
by
to
that.
you, whatever have been deposition should be ignored. Okay. Let us not consider a deposition of witness so and so or what they said about the evidence.
That-
So we'll only look into the evidence material as in the case diary.
Case report. Because Lordship knows if today my friend's client was seriously ill for some reason, Lordship will grant him bail. That is another matter. But it would not be a matter of course.
But then still we would like you to a judgment or if there is a possibility, Nargis also
Lordship that
on this point. When you say case diary, he says, well, statement made by this Sahidul or whatever, they are also accused. When the police makes investigation, what is case diary? Case diary, section 172,
173,
72,
72, yes.
72,
CRPC.
CRPC, diary of proceeding in investigation, case diary. What is case diary? Please read.
Diary of proceedings in investigation. Every police officer making an investigation under this chapter shall day by day enter his proceedings in the investigation in a diary, setting forth the time at which the information reached him, the time at which he began and closed his investigation, the place or places visited by him, and a statement of circumstances ascertained through his investigation. 1A. The statements of witnesses recorded during the course of investigation under section 161 shall be inserted in the case diary. The diary referred to in subsection 1 shall be volume and duly paginated. 2. Any criminal court may send for the police diaries of a case under inquiry or trial in such court and may use such diaries not as evidence in the case, but to aid it in such inquiry or trial.
Anyway, now just we'll pause for a moment there. Now, what the case diary says, Statement of all the witnesses. Okay. Will it include the statement made by an accused also in the case diary? Is the statement made by an accused in the investigation, during the investigation, be part of the case diary?
Here specifically mentioned statement of witnesses
Correct.
recorded during the course of
Okay, very
investigation.
well. Not accused. You want to say that not accused?
No.
Fine. In that case, Nargis, how we are going to use section 27 of the Evidence Act? What is section
That is-
27
that-
Evidence Act?
That is quite different, Lordship.
Oh, 27 is part of the statement made by the accused.
But there is specific, yes, but
Section 27 of Evidence Act is part of the statement made by an accused during investigation which leads to discovery of fact.
yes.
Only that part which is relevant, correct? But then that we'll see later on. But then first of all, he has to make a statement.
That must have to record under this, evidence, under section 27 of Evidence Act.
Oh,
Yes.
no. There is
Yes.
nothing like, in the
Yes,
case, there is
all
nothing like,
full answers are there to that regard.
correct. It is part of that section 27.
Yes.
Section 20, what is section? Section 27
Leading
is
to
a,
discovery.
is an exception to the statement, section 27. See, otherwise, see, section 27 is the exception to section 25. Section 25, the Evidence Act,
Yes,
any statement when confessional made
yes.
is section 25 of the Act,
Confession to police officer
Ah.
not to be proved.
not to be proved.
Yes.
We are not at this stage, there is nothing, there are not, nobody is seeking proof here. We are, that is for the trial, at the trial. But confession he can make, no? Can he make confession to the
Confession
police?
before the police.
He can make,
He can make, but
but it will not be useless according to you, no problem.
not
That is
according to me, according to law.
law, very well. According to law, it will be useless, fine. But then that portion of the confession which leads to discovery will be admissible. Yes, Nargis.
Yes, I got.
If that is so,
Ah.
from where you will get that portion which will be exempted by section 27, it will be part of a statement. Section 25 makes certain exemption that if it leads to that portion of the statement which leads to discovery will be admissible. If that is so, then it presupposes a statement made by an accused. Some statement out of
there is-
that portion,
Yes, Lordship, but
therefore, that statement where it will be recorded? Will it form part of the case diary?
Lordship, to that
So-
regard, they must have to record under 27 of Evidence Act. But it is not recorded under 27 of
No,
Evidence.
no. There is nothing like that. In the case diary, the police does not say, I am recording the evidence in the section
But there
27.
must be condition for leading to discovery. Leading to, there is no leading, there is nothing about that leading to discovery.
Oh, we are not on that. No,
But
we
that
are
is-
just on a legal, we are just trying to understand. When you say, because he says, he is again trying to bring this pace, because Mr. R.K. Dev, his mind is always towards page 73, page 73. There is a statement made by the accused, Saiful.
Sidewalk.
Then you say, sorry, 73 you can't read because of 162. Well, we understand the statement of an accused cannot be used. Fine. Question is now in section 43D, it says on the basis of what? Case diary. Now, therefore, we go into the, what is case diary? Case diary, what is the meaning of case diary? Case diary. Case diary means everything, whether admissible, non-admissible, it contains all in the basket. In the trial court, when this basket is produced, basket full of evidence will be produced, the judge will say, oh, this is a rotten, not admissible, throw it away. I will not see.
No,
But then the prosecution is entitled to produce the basket full of evidence. And the trial court will say, oh, this is not admissible, throw it away. Throw it away. We will not look into it. We will only look into what is admissible evidence. But you will get that admissible evidence from the whole collection of facts, evidences. What we are trying to say is that case diary therefore contains all kind of evidence, maybe not admissible also in course of the trial. Yet nevertheless, case diary means recording of what he had found. When the investigator, IO, makes an investigation, he meets the accused. And okay, what did you say? You are accused? Okay, fine. What did you do? Tell me. Then he will record. But those will be inadmissible. Only that portion which leads to discovery. But he has to make a record. Or no. Therefore, you mean to say that the IO will not make the even record the statement of an accused?
He can record.
Huh?
But he can record.
He can record where?
He can
Where
record,
that record where it will be kept? That record.
but that is why there is law.
Huh?
There is law.
He can
whether it is
record.
or not.
Ah,
Made before the police as per
that
Evidence
is
Act. that is-
correct. That will be at the trial. At the trial stage, you can say,
Lordship,
Your Honor, this is the statement made by the accused. Self-incriminating, not admissible. 162 was there. Section 20 of the Article 20 of the Constitution. 2. Article 22 perhaps.
Yes.
Self,
20.
not admissible. You can say that in the trial. But we are dealing with not trial. We are dealing with a bail. And what does the bail
But the
UAP says?
Lordship is dealing with a bail in an appellate court. In the appellate court, what is an appeal, Lordship? In
Appellate court, we
Yes,
also
Lordship. There is no bar to in the appeal.
no, correct. But we also see whether the trial court has committed any illegality. First, we'll see that. If he has committed illegality, then we'll see what order we can pass. If the trial court has not committed any illegality, then why should we exercise?
No, that is
Our exercise will come. That exercise that you mentioned, that is the High Court, fine.
No,
We'll do it when the lower court has failed to exercise. Then what shall we do?
But yeah, our full bench judgment specifically.
Therefore, football says, therefore,
No, Lordship, let's say.
the
complete
legislature,
responsibility.
correct. No, para 30.
31 also.
No, we'll do that. We'll read that.
No, I have not
Any material beyond the case diary.
Yeah.
We are not on that.
Case diary, as per this case diary, as per section 173, report of police on completion of investigation.
Oh, madam, we are not able to understand.
I understand. I understood, Lordship.
You have understood.
Yes,
But
ma'am.
maybe then we are not
But-
able to understand you then.
Lordship, there is.
Either there is some problem with us, because there is some misunderstanding going on that I can feel.
Lordship specifically mentioned the section 173. 176 says,
Oh, why you are bringing 173 UAP Act? We are
no,
only,
it's not 173 of CRPC.
we are concerned with not CRPC, we are concerned with the UAP Act. Section
The rest of the section follows the CRPC.
No, but then section 43D,
Specifically mentioned in 43D, 173 is master
correct,
to
or, correct,
perusal.
or, yes, perusal of the case diary, or, it doesn't say and. In that case, either they can rely on case diary or police report. Or, either of these.
Is that
So,
your-
So if they rely on case diary, what is wrong with that? And what is case diary? If you say what is case diary, does it contain the incriminating statement made by the accused himself? If you say no, then fine. We'll ask Mr. Dev not to even look at page 73 again.
During
Huh? Huh?
I look into another judgment.
No, what we are trying to say is that we understand your position. Yes, because see, normally we don't look into the statement made by an accused. Normally, under normal criminal, we don't normally look because every criminal will say, police will say, "Arey, come on," then they will record. So normally we are skeptical. We don't rely on statement made of the accused. There must be some corroborating, something must have been
Lordship,
recovered.
Recently, 2020, in another act, our apex court full bench judgment is there. under NDPS Act regarding the 67 and 161. Tufan Singh.
Okay, you produce that, we'll see.
Right now, it is not with me.
But then
But
in
it is-
NDPS Act, there is no
My
such
lordship
provision.
is aware about that.
Correct, Nargis.
All these things
In
discussed.
Nargis, in that case, in NDPS Act, there is no provision said that the trial court is to look into the case diary only, or it doesn't say, there is nothing reference to case
No,
diary
no,
or
I'm
one
not on
police
that.
report.
I'm not.
No, but we are on that.
No, no.
We are trying to understand what is the meaning of case diary.
No, I'm only regarding this 161, differentiate between 161 and 67. So what is the meaning of 161? That is
We know what
described
is
in that case. lordship.
161, we know. But question is that when the section 43D says on perusal of the case diary. On perusal of case diary,
Lordship, kindly peruse the next paragraph also of the Judge Rosenborg. Last,
correct? Okay, what does it say, Rosenborough? You tell, yes, we'll read.
in
Tell us.
view of the discuss,
Above.
discussion made above, we are of the considered opinion that the view taken by the division bench in why brother Bidu Singh
Hmm.
that once charge
Charge
is
is
framed against an accused for an offense punishable under chapter 4 and 6 of UAPA Act, and unless
Yes.
same is challenged and set aside by a superior court, the accused would not be entitled to bail in view of the proviso to subsection 5 of section 43D of UAPA Act does not lay down the correct law. This view taken in why Brother Bidu Singh is thus overruled. As a consequence, question number 1 is answered in the negative by holding that a person accused of an offense punishable under chapter 4 and 6 of the UAPA Act and is under detention for the same would be entitled to a consideration for bail under section 43D(5) of the said act, irrespective of whether charge is framed against the accused or not, subject of course of limitation imposed by the said provision and having regard to the object thereof. This is held by
We are
our
considering, we are not limiting ourselves. We are even going beyond trial court also. But then still you have to consider on the basis of perusal of case diary or the report, because they will say the case, there is a prima facie case against the accused on the basis of case diary. And Mr. Dev would say, case diary also includes the statement of the accused, though it is not admissible in law under 162 CRPC. But that is to be considered at a time of trial, not at a time of consideration of bail, because it says case diary. Case diary includes every statement made by everybody, including witness, including accused. That's what he's trying to say. Therefore, we are saying, okay, in that case, please tell us. Tell us any judgment. When you say case diary, it also includes the self-incriminating statement of the accused. You may say, no, why should it be considered? So both of you please look into that. What is the meaning of case diary? Because you will not get a judgment relating to UAPA Act, maybe, I don't know. But I just want to know, we just want to know what is the meaning of case diary. Because the UAPA Act says on perusal of the case diary. So the judge can look into the case diary. Can the judge look into case diary? Then what does the case diary contain? You think that case diary, when the police will produce a case diary, they will take away this statement made by the accused because it is bar under 162. That will be done at the trial stage. They will say, no, Your Honor, please see this also because it's a part of the case diary. Have you understood us?
Yes.
Now, thank you for understanding, because there was some problem earlier.
Even we also don't tend to understand.
Now, I'm just again putting it very briefly. We'll come to that. Don't worry, Nargis. We'll examine Brozen also, all aspects properly. We'll What is not permissible in law, we will not do it. What is permissible in law, we'll consider it. Question is, section 45D says, provided proviso,
Yes,
please,
yes, yes.
provided that such accused person shall not be released on bail or on his own bond if the court, on a perusal of the case diary, after perusal, then the court has to make an opinion. What is that opinion? That there are reasonable grounds for believing that the accusation against such a person prima facie is true. That will come.
Yeah.
First, he has to look, the court has to look at certain material. Then he has to make an opinion. There are two stages. A judge has to discharge. First of all, first he has to look
Yeah.
the documents. What are the documents to look into? Case diary. Then he has to form an opinion whether it is prima facie true or not.
Yeah.
If the court feels that prima facie true, bail is rejected. If there is no prima facie not true, bail is granted. Okay. The formation of opinion is subsequent. But before forming his opinion, he must look at certain material. What is to be looked into? Two options are there before a trial. Case diary or the report made under section 173 of the code.
Hmm.
So the court can look into case diary or 173 report. It does not say only 173 report. If the court see that was the UAPA slightly difficult proposition. It does not say that if the report is made under 173, then you can look into case diary, because case diary contains all kind of materials. What time the police went to the place, what time he examined, how many witnesses he examined, did he try to catch the accused? All those things have to be, this diary is a diary, noting down what he had been doing. I woke up in the morning, went to the police station. From there, I went with this so and so with the vehicle. We tried to look after, he was not found. All those things have to be written in the case diary. So therefore, you can imagine that this case diary is a bundle of facts. Whether these are admissible, not admissible, that will be scrutinized by the court. The court will say, your case diary is useless. Nothing is shown. They're all irrelevant matters. You have been talking to people you are not supposed to talk. You are not arresting the person. The court will, that is for the court to decide. Application of judicial mind on the material so collected. But then law says on perusal of the case diary. Now, R.K. Davis case diary. Oh, case diary means this statement made by this accused Sahidul also. Therefore, please look into it. And you will say, no, you cannot look into that, because statement made by Sahidul is barred by law, isn't it? Barred by law under 162. But that is a plea is to be taken now or in the trial. Please, that's what I'm trying to say. If you are able to say, yes, even if this statement of the accused is included in the case diary, the court cannot look into it at all because it is not permissible. We will not look into it. But the court says on perusal of the case diary, law says, the section 43, on perusal of the case diary. Therefore, does it mean that on perusal of case diary only the admissible evidence? Does it say so? That means, are we going to decide admissibility also at a time of bail consideration? You to tell us.
As per the full benches.
As per full bench. Correct. We will not go into the evidence recorded in the trial.
Recorded after framing of charge.
After from case, we are not going to look into. So don't worry. Your fear, your apprehension, be rest. You are not going to look into those statements. No, I did not make. These were not voluntary. You are not going to look into that because of the full bench. So, but then we look into the case diary. Can we look into the case diary? Nargis, can we look into a case diary? Can we look?
I need to search to that regard.
Can we look into the case diary? The law says so, perhaps. Huh?
Yes, proviso is there.
If I can look into the case diary, then what does the case diary contain? I can look into whatever is there in the case diary.
Definitely.
Then therefore, can you delete that statement made by an accused, which is recorded in the case diary?
In that case, whether 161 is admissible or not, that question will arise.
Oh, Miss Nargis, 161, whether accused or non-accused, everything is gone. Even witness also cannot be considered. Law is not only of the accused, law is of everybody. Any 161 statement cannot be at all admissible except for contradiction if it is a witness. Otherwise, 161 also not admissible in law. Forget the accused, even for a normal witness. There is no evidence.
During the investigation, if it is with the search sheet, they relied upon that lordship is submitted.
That is what we are asking you. Therefore, we are asking you, what is the evidentiary value of a statement of an accused in the chart, in the case diary? Because the law says you can look the case diary on perusal of the case diary. The law requires a judge to look into the case diary or the police report. It does not say case diary and the police report. If it is and, then what will you do is that if you see case diary, then you will say, oh, these are all not admissible. Case diary, because police report, sorry, the police report, the police shall be complete without unnecessary. But again, the police report also will contain a lot of materials which may not be strictly admissible in law. That is for the court to decide later on. But at the bail stage, it will contain what we are trying to say is that this either police report as well as case diary may contain all kind of materials which you think is not admissible in law. But it does not say that on perusal case diary or police report minus inadmissible evidence. It does not say that. Minus is not there. Minus is there whenever trial, whether it is there or not, we will apply minus. In the trial court, in the trial, if the prosecution wants to examine inadmissible, we will say no, we will stop him. You cannot. If the prosecution wants to read out 161 statement, we will say no, you cannot do that. You cannot use 161 statement prosecution, we'll tell them. Even though the law does not specifically mention, isn't it? Suppose they want to produce this 161, he said in 161. That can be used only for the moment he is declared hostile. Prosecution witness, once he is declared hostile, then prosecution can say, yes, no, what you said this in the investigation. That is another thing. But otherwise, 161 cannot be used by the prosecution, neither by you also. You can use it only for the purpose of contradicting. If the witness says something else.
Contradiction and corroboration.
No corroboration. What corroboration?
Prosecution, if
What corroboration?
prosecution relies
Who says corroboration? Which provision is there? What is the provision that under that evidence say it can be used for corroboration? Who said?
161 statement, if the witness at 161 on the basis of this statement of the witnesses, charge sheet submitted.
Correct.
So if along with their prosecution relies upon these witnesses.
So
If
you
any
look
charge-
into this. We'll continue tomorrow or day after tomorrow. Tell us.
Day after tomorrow, I think it will be possible.
Day after tomorrow. Okay. Hearing will. Huh?
And tie down with the PMLA matter day after tomorrow. It will take the whole day.
Tomorrow, Lordship fix another matter, that is why.
Where PMLA matter? Where?
Code number 12.
Huh?
In code number 12, Lordship, it's part
Code number 2.
12.
12.
It's part of Lordship.
Today is what day?
That is 27.
Today is 27. 28. What about tomorrow?
We need little bit time because of this Lordship.
If it can be on Friday, Lordship.
That is
Friday.
the last day.
Eh?
We
Let's
can
take
do.
a chance.
We can.
You try your luck. You try. Do you see, because we are going to certain areas, see, on perusal of the case diary,
Yes, Lordship.
because you have been again and again objecting to the use of page 71.
Lordship is correct, but thing is that already decided by the full bench of our High Court.
Yeah.
That is after framing of charge, that means if even after perusing of the case diary, charge frame against the accused person, in that case, the honorable court can grant the bail.
Yeah, we can grant bail if you are able to satisfy us. Don't worry. We will grant you bail if you are able to satisfy us that it is not prima facie not true. We will grant you bail.
Premise true.
If it is prima facie true, it will be rejected.
No, Lordship. Lordship. In the this Rosenborg case, already charge frame.
Doesn't
That means
matter.
prima
Forget.
facie true was there.
What do you want?
No, prima
You
facie,
want bail?
exactly, Lordship.
You want
That
bail,
one
no?
is-
But to grant you bail, we have to be satisfied that the case against you is not prima facie true, isn't it?
That is why, Lordship, before passing this judgment in our High Court, all the time, all the cases rejected by this division.
Oh, I don't worry about it. Don't bother us. We will just go.
This is referred to the full bench.
Just don't bother. Don't shackle us with anything. We are saying we'll grant you bail. We will grant you bail if you are able to convince us that the charge against you is prima facie not true. If Mr. Dev is able to show that the charge is prima facie true, then we'll reject your application, isn't it? Or correct or no?
Yes, if true, but
Ah.
I am on that, Lordship, only.
Then one done. What you are on? Then we have to undertake this exercise.
Yes. My contention is that in this
You
judgment,
mean to say that this as an appellate court, you don't have to bother about it, prima facie and all these things. You take a decision on some what
No,
principle?
no.
Then
I'm not on that.
then
I'm not on that.
then
But this is full bench judgment says that
Ah.
even after framing of charge, that means
yes, correct. Even after framing of charge, now also when the trial is going on, we can grant you. Huh?
After considering this document that there is a prima facie.
No, brother. Your full bench says that you cannot consider the evidence after recording of the any recorded evidence.
We are not on that. If Lordship
Again, what do you are not on that?
Lordship, if Lordship do not want to look into that.
I don't. It's not that I don't want to. The full bench says that don't look into that evidence which has been recorded after the
But
charges is
in
spread.
their evidence, there is nothing against me.
Huh?
In their evidence, nothing against, because
Which evidence?
in their.
No, we are not. No, we are not in that. We will just go to the case diary.
They relied the witnesses. One of the 3 persons came from Kashmir. One of them made witness in this case, and his statement recorded 164. In his 164 statement, he has not mentioned a single word against this accused appellant.
Lordship, I will hand over the case.
Handling of
What?
this case, there is.
I've got the case diary, Lordship. I will, is it?
Okay, we don't keep it your safe custody. We don't have any safe custody. Our all they all open. Huh?
Right now, my learned friend read the this hostile part of the witnesses. If Lordship, he is,
That will be in the.
he
trial.
he wants to say that Lordship cannot go this deposition of the witnesses, but he has read right now that part. But if Lordship avoid this part also, in that case also this Kashmiri person who relied by them, he has not whispered the name
Lordship,
of
I
the
will, then
petitioner.
I will again reread the Hindi part. Lordship, that will be prior to the deposition.
That's the thing.